Item number 1 and 2.
Item 1, madam, the issue of maintainability was to be taken up today.
May I please, my
One
lord,
and two are connected.
The challenge is to the same act. That is why they are, otherwise item 2 has already been admitted and it was fixed for hearing. But since they are challenging the same act, that's why they are tagged together. But otherwise in item number 1, the issue of maintainability was to be decided.
On what grounds?
On several grounds, man.
in item number 1, my lord, there's a petitioner had want to engage some other advocate. In earlier occasion, I have submitted the same matter. It is recorded in the order sheet, my lord.
So that was on 5/1/2020.
Yes, my lord.
More than a month has passed.
Yeah.
Petitioner do not seem to be interested.
He told me that he will engage another
Till now,
advocate.
there is no engagement of new counsel. One petitioner, how many petitioner? One.
One, my lord.
He doesn't seem to be interested in pursuing. And in any case, Mr. Sona's case writ petition is on the same issue.
My lord, so my lord, this matter has already been, my lord, admitted, my lord. May I pray, my lord, this matter may be segregated and my matter may be fixed for hearing, my lord.
No, there was an order for having an analogous consideration.
My lord.
Either we dismiss the first petition or we hear it together, or then the question of segregation perhaps will come later. Okay, you are not the counsel now, so we cannot say anything.
We give a last chance. We have it on tomorrow. Have it tomorrow, because tomorrow and the Thursday were divided. Tomorrow, we give it another chance for question number 1. Item number 1 to 7. If not, we'll discuss it for non-prosecution and we'll make an observation since the issue is already been covered by the simple not prejudice to the court. Okay.
We'll do one thing, we'll give a further chance till tomorrow. And tomorrow, if there is representation, well and good. If there is, then we hear on the maintainability part. And if there is no representation, we can tentatively say that we'll dismiss it for non-prosecution. We'll also make an observation that whatever rights interest will be there will be covered by the item number 2.
In that case, my lord, I have to be in Guwahati tomorrow. Can it be?
Thursday?
I'm supposed to be here again on 23rd and 24th, any of those 2 days.
No, see, Mr. Chaudhary, let us have it tomorrow. If petitioner appears and you want to raise an issue of maintainability, then we'll fix the date. Otherwise,
in that case, my lord, my friend will be.
yes, item number 1, in case of non-appearance, we'll close it. And 2, we'll fix the date of hearing as per your convenience. Okay. 3 N. Taji, learned. I heard 3 N. Taji, learned counsel for the. No, don't say. 3 N. Taji, learned counsel for the petitioner in PIL 18 of 2024, by referring to the earlier order dated 5/1/2026, has submitted that the petitioner wanted to engage another advocate. Full stop. Also heard Sri R. Sonar, learned counsel. No, don't say also. Sri I. Chaudhary, the learned Advocate General of the state, has however submitted that there are a number of grounds questioning the maintainability of this PIL. We have however noted that since that more than a month has elapsed since the last order and there is no engagement of new counsel. We have also noted that the connected matter WPC 136 of 2021 is on the same subject matter. Considering the same, a further chance is granted to the petitioner to engage a counsel, and these matters are directed to be listed for consideration tomorrow. 3 R. Sonar, learned counsel is present for the petitioner in WPC 136 of 2021. And I. Chaudhary, assisted by Sri S. Sabu.
Item number 3.
My lord, as per the last order, we were supposed to file our affidavit. My lord, in fact, we have received the draft pair-wise reply. But the main para-wise reply, it has gone for low betting. That's why we
We have
require
been
some.
granted time on a number of occasions.
Yes, my lord,
Matter pending since long.
yes.
Mr. Parme,
My lord.
what do you say? He's asking for some more time.
Yes, in fact, as per the draft para-wise comments also, it is not against the petitioner. It's
It
for
is?
not against the petitioner.
Then you
It's
should be
for-
happy.
Yes. At least
But if
that,
the final draft comes against you, there is a caveat. He said, final draft has gone for vetting. Okay, we grant some time. How much time?
my lord, at least 2 weeks then, my lord.
2 weeks, no? 3N Ratan, learned AAG has submitted, AAG appearing for the state has submitted that the final instructions for filing the affidavit in opposition are still awaited, though draft instructions have been received by him. Para? He accordingly pays for and is granted 3 weeks further time to file the affidavit in opposition. We'll give a date, Mr. Ratan.
Yes, my lord.
Today is 9th.
Nine.
1, 2, 3. We'll have it on 8th of, 6th of March. Is it okay?
9th of March.
9th of March.
Yes.
Then 4 weeks, 3 weeks and 4 weeks already. 9 March.
Obliged, ma'am.
Item number 4.
Your Lordship, pleading counsel for the appellant is out of station and the letter of absent is already submitted. Your
Yes,
Lordship,
what is this matter? Writ appeal? Permit, for the power department.
My lord. They are claiming equal pay for equal work, my lord.
That was dismissed by the honorable single judge.
My lord.
Your Lordship, matter may be fixed for after 2 weeks.
On a request made on behalf of the appellants, matter is adjourned to be listed after 2 weeks. Sri L. Parme, and Standing Council Power is present. Power Department is present.
Obliged.
Item number 5.
Yeah, please, Lordship. Lordship, parties, we are ready for disposal, Lordship.
Hmm?
We are ready for disposal of the matter, Lordship.
Where is it for orders today?
Order. In fact, my lord, what I understand, it ought to have been for admission.
It should have been.
It's state's appeal.
Yes.
What do you do? Tell us.
Lordship,
For disposal.
They are ready.
If both the parties are ready, we can take for disposal.
Lordship.
Yes.
But single bench, how many matters are there? How long will you take, Mr. Talk?
Lordship, around 1 hour. Lord.
Final.
28. There are single benches, many matters are there. We don't mind hearing this matter, but other matters should not suffer. Today is Monday also, motion day.
Lordship.
Mr. Dottok, are you here till tomorrow?
My lord, subject to what your lordship.
And tomorrow is a normal DB. We have been informed that Tuesdays and Thursdays are normal DB days. Monday is an exceptional matter since
Lordship, tomorrow,
No, we don't mind hearing. If you can reduce your time by, you can finish by 45 minutes, the entire matter, we can hear it today, so.
Your lordship will take tomorrow, my lord.
tomorrow I have some difficulties, Lordship. Tomorrow, day after tomorrow, and then next Lordship. Up to 12 Lordship, I'm with some difficulties. I would be out of the session.
Oh,
And today, my lord, subject to what my learned friend submits, I will not take much time. The matter is very short.
he takes 1 hour.
Uh,
And if he takes 1 hour, he'll not take more than less than 1 hour. That we know.
Well, the matter, of course, my lord, it's all dependent on him.
What is the issue?
Issue is tender matter, Lordship.
The tender we have seen.
Yeah,
What is
Lordship.
the issue?
Basically, what happened, the read petitioner, Lordship, he was not awarded the work, but he was somehow allowed to execute the constructions of the bridge, Lordship. In the meantime, Lordship, the government decided that it will go for the tender, Lordship. And that communication has been challenged by the read petitioner, which has been set aside in course by this learned single bench.
No formal order was issued.
No
to-
formal order was.
No, the matter is not that at all, my lord.
No, that may not be the,
Yes.
that is his projection.
You're right.
Lordship.
We have not accepted that. We only wanted to have an idea what is the matter about. If you are agreeable, you can finish the entire matter by 1 hour, we don't mind hearing, but
1 hour, I doubt, my lord, learned friend will finish it within 1 hour because he will go to so many things which is not necessary at all. Before the last
you
division.
could anticipate in advance.
No, my lord, what happened? The last division bench, I was doing it through video conference.
It
from
depends on the
Guwahati.
bench.
Beg your pardon.
Last division bench was not us.
No, my lord.
Depends on the bench.
Justice Habung was there. My lord, my learned friend argued to so many things which is not necessary at all, my lord. So therefore.
That is what he was complaining, that last time there was time wasted, so this
Yes.
time he'll not allow time wasted.
Rightly, my lord.
That's-
It was the last
that's the way.
thing. And then, my lord, the end of his argument, I will just made in the submission before the court that I will demolish him the next day.
Demolish.
Demolish his argument.
Oh, not him.
Oh, no, he is my friend, my lord, I can't. So that's the position and he will obviously take not less than 1 hour.
If the aspect of
Let's say in-
demolition comes, then we should have another date, I think. We should also be properly equipped.
कल कर दो ना आदमी.
My lord, I
Then
was thinking,
It may be fixed on 18, otherwise Lordship next week.
Next Tuesday.
Yes,
Have
on-
it on a Tuesday or Thursday, designated DB day.
Wednesday and
It's on Wednesday.
Which day?
Tuesday and Thursday, usually we used to have DB, but Sari is fixing on 18th.
No, wait, have it on Tuesday or Thursday, on a designated DB day.
in that case, my lord,
You have a date of your,
can I suggest to your lordship?
please,
My lord,
otherwise Friday we can have. Friday I'm available.
this Friday.
This Friday.
Friday.
so many fixed cases are there.
No, not on Friday. Have
Oh,
it on a
look.
Tuesday or any Tuesday, Thursday of both of
24th.
date of your choice.
No problem.
My lord, 24th of this month.
24th we can have. 24th is what? 24th is
Tuesday, my lord.
Tuesday. Okay, 24th.
No problem.
But we'll have it for make
Admission.
admission,
Admission.
and we will also make an indicated list for final disposal.
Right,
Okay.
very right.
Okay. Heard Priya Tapin, Learned Senior Advocate for the state. Also heard Shreyas Datta, Learned Senior Counsel, assisted by Siddhant.
Yes.
Siddhant Datta. For the contesting respondent within bracket petitioner. How many petitioners are there? One, two,
Read petitioner only one read petitioner.
one.
One.
Who is the second one in this appeal?
The second one, my lord, the two other orders were challenged.
No,
It
no.
was
The read petitioner, the PAM and the proprietor, two
Okay,
petitioners.
so
are there.
petitioners, huh? Two petitioners. Okay. The learned council are in agreement that the matter should come, and the learned council for the parties have jointly submitted that the matter ought to have been listed for admission here. Full stop. It is also submitted that in the admission stage, the appeal can be taken up for disposal
Yes.
as it involves a tender.
Yes.
Involves tender for construction of a Bridge.
Bridges, six bridges.
Para? Considering the above, list the matter for admission hearing on 24/2/2026.
No, sir.
On which it endeavor be made for disposal of the matter.
Close. The interim passed earlier, maybe.
Interim order passed earlier to continue with
Interim
the
order is
process.
needless because the work is already stopped, my lord, because the lack of fund. So therefore,
It doesn't, in the next declaration. Okay.
publish.
And what are the other matters? Similar, second WA,
Close, same.
Why
Because
why
two read petitions were lordship disposed of
two works,
by common
two
judgment.
works.
Yes.
Same works.
In connection to same issue, lordship, two read petitions were.
Okay, do that, okay.
Item number 7.
My lords, there's inadvertently, there's a mistake in the address and the name of the respondent number 7 or 5, my lord. So, my lord, I seek my lord's permission to correct and take a fresh steps, my lord. Otherwise, this is an interlocutory
I
application.
for what?
This is an application under section 5, Condonation Act of the Limitations Act.
And
my
you
lord.
need to file connected an IA for amending the cost title.
My lord, otherwise, my lord, if my lord permits, I'll correct in the petition itself,
No,
my
it
lord.
cannot.
Just my lord.
You could have done it earlier, but now after
Well-
this, new CIS, you can.
My lord, my lord,
It's a normal two-page application.
my lord,
We'll allow it, okay?
my lord.
Your Emratan,
My lord, P. Yobin, my lord.
PUB, your name is not there.
It's there in the Vakarana, but not in the cost title, cost list.
Registry does not like you.
My lord,
You should meet the registry, go there,
my lord,
talk to them. PUB, huh?
my lord.
PUB letter counsel for the applicant has submitted that though there is an office note dated 7/2/2026 regarding failure to take steps on the respondent number 5,
My lord.
comma, the description of the respondent number 5, qua his address, has been improperly put, and there is some inadvertence. Due to some inadvertence, he accordingly prays for a liberty to file amended cost title
My-
with the correct address of the respondent number 5.
My lord.
Full stop, para. Also heard three, R.H. Nawab, the learned AAG. Hey, madam, you're also appearing for somebody?
My lord, she is assisting me, my lord. I'm representing 1 to 3, my lord.
1, 2, 3, along with Ms. P. Pangu, Learned State Council. Correct? In view of the above, let liberty to file I for amendment of cost title qua the respondent number 5 is allowed. The aspect of directing steps to be taken upon the respondent number 5 will be taken up after filing of such I.
My lord. Obliged.
Item number 8.
Hearing matter.
Seeking adjournment on behalf of M. Biswas. He's from Guwahati and he is not unable to attend today due to personal difficulties.
Online facility is there. It's a 2020 matter.
Yes, sir.
If he has a difficulty in traveling, he can address online. He has got such good facilities here.
Yes, sir. Lots of instruct me picks on next week.
Mr. AG, when will you be available?
I have to come back again on 23rd and 24th.
And we'll have it on 23rd or 24th, whichever is the designated DB day.
24th.
24th. Okay, 24th.
Yes,
If he's unable to appear in person, please instruct him to address online. Okay, these
Yes,
are
sir.
all matters.
Yes, sir.
Okay. A prayer for adjournment has been made on behalf of Sri M. Biswas, Learned Counsel for the petitioners. Also heard Sri I. Chaudhary, Learned Advocate General, assisted by Sri S. Tapin, Learned Senior Advocate for the state. Para, considering that this matter is pending since long, while hearing is deferred, comma, the same is directed to be listed on 24 2/2026. Full stop. Further prayers for adjournment may not be entertained by this court.
Item number 9.
Item number 9. Yes, Mr. Tapia.
This is still appeal again, Lordship.
Hmm?
This is our appeal, Lordship, again. This is about the regulations of the service and also involve the Lordship equal pay for equal works, Lordship. So
Madam, you are appearing for whom?
For respondent, Your Lordship. Writ petitioner respondent.
Okay, okay.
Order was passed directing the state respondents to pay the minimum pay scale at the present post, Your Lordship.
Like Upendas. In the lines of Upendas.
In the line of Jagjit Singh.
Jagjit Singh and
Lordship.
the DB which has followed Jagjit Singh.
Lordship.
Upendas, I think.
Upendas.
45/11.
Lordship.
So what is the difficulty?
Lordship, if Lordship
That
see
is the minimal thing.
Yes.
Lordship, the aspect, Lordship, so far whether they are working as a Lordship in that equal capacity and then Lordship with that nature of work and all, Lordship, those aspects have not been, Lordship, considered in the writ petition.
The nature of work is not similar.
Here one is even peon, Lordship. If Lordship see the judgment,
We hear this matter, how long will you take? We hear it.
in the may start, Lordship. Actually, Lordship, the writ petitioners, they are working as a casual, some are typists, Lordship, and some are, Lordship, computer operator.
How many petitioners are there?
They are
Seven.
seven in total, Lordship.
7 writ petitioners.
Seven writ petitioner, Lordship.
Okay.
They are working in the Western Zone, Lordship.
Western Zone.
Western Zone, under PHE, Public Health and Engineering Department, Lordship. Here, out of 7 petition, Lordship, petition number 1 and 6, they were engaged as, Lordship, LDC. There's a lower division clerk, Lordship. And petition number 2, 4, and 7, they were engaged as a typist, Lordship. And petition number 5 and 8, they were engaged as a, Lordship, computer operator, Lordship. And petitioner number 3, she was appointed as a peon.
3 peon.
Peon, Lordship. During the course, what happened, Lordship? 5 private respondents, Lordship.
Yes.
From the Eastern Zone, Lordship. Eastern Zone, they were, Lordship, promoted in capacity of work charge, Lordship. Don't see, Lordship. And those appointments were challenged under the writ petition, Lordship. They are from, Lordship, the Western Zone, and private respondent were from the Eastern Zone, Lordship. And so far, Lordship, appointment and promotions of the work charge is concerned. This is purely done by the concerned superintendent of engineer, Lordship. This is done in circle level, Lordship. Because appointment, the work charge is always appointed against the particular work, Lordship. So therefore, Lordship, the seniority of the laborers, Lordship, and work charge and all are maintained in circle wise. They do not form the, Lordship, common seniority list of the state laws. So competent authority for appointment of work charge and appointment of laborer, they are by the SC concerned, Lordship. They challenge the, Lordship, The appointment of the private respondents.
Who are for the private respondents here? No, they are the petitioners.
Oh, no.
Lordship, the private respondent which we met as a party in the writ petitions, in the appeal, they have not met them as a party.
Thank you.
They have not met them as a party, and then also
Why,
they have,
Mr. Tapin, don't you think?
therefore, I'll be raising maintainability of this appeal also, Your Lordship. Even our affidavit in reply also, they have not annexed.
At least they have to be made as pro forma respondents.
Just now,
This was
Learning-
At least if you are not seeking any relief against them in the appeal,
no, sir.
and since their petition got dismissed, they may not have any resistance in your appeal, but you are required to make them prior. Did they contest the writ petition?
Yes, Your
Yes.
Lordship. They
They're
filed a
contested.
written statement also.
But just can you see one here, Lordship? So for the writ petition is concerned, Lordship, 3 issues were, Lordship, formulated by the London Single Bench, Lordship. The issue number 1, that was, Lordship,
The private respondents have not filed any appeal.
No.
No. Here kindly see the issues, 3 issues. Whether the appearance of the private respondent would be required or not.
No. See, Mr. Tapin,
No, sir.
there are 2 issues. In effect, there may not be any impact on their. In fact, the fact that they have not come up in appeal would show that they are not too much affected by this order of the Honorable Single Judge.
Lordship.
But they were parties in the proceeding, original proceeding.
Lordship.
And writ appeal is nothing but an intra-court appeal. You cannot just exclude somebody at your own choice. You can at best make them pro forma respondents.
Correct, Lordship.
Then also, but we cannot exclude them totally.
Uh,
That will not be a recognized or a fair procedure. You cannot deprive somebody from resisting. They may not.
Lordship.
That's a different matter.
that part, Lordship, I agree with the Lordship.
I think
But even Lordship, see, because this is a state appeal, Lordship. And so per issue, they challenge the appointment of the private respondent.
let us not go into this issue. You file an application for implement. It may be private, pro forma respondent, it may be respondent. We'll allow it. Let there be no
Lordship,
difficulty tomorrow.
just the issue number 2 here, whether the private respondent number 5 to 8 were appointed as work-charge employees without following the due procedure of law. And on such count, their appointments are liable to be set aside or quashed, Lordship. So far, this issue is concerned, Lordship. It has been negative by the London Single Bench, Lordship, and which has not been appealed by the petitioner. Therefore, Lordship, this issue has gone, Lordship. So far, the private respondents are concerned, Lordship. Their issue, Lordship, even the outcome of the present appeal would not be affecting them, Lordship, in any manner, Lordship. Had it been, Lordship, the challenge by the writ petitioner by way of appeal, Lordship. So far, this issue, the considerations of this issue is concerned. Then, Lordship, I understood, Lordship, without hearing them, we can't proceed, Lordship. But since this issue has been negative by the London Single Bench, not appealed by the writ petitioner, so, Lordship, they will not be affected, Lordship.
See, writ petition was, as a matter of fact, not in dispute, that the private respondents were parties. They had contested the writ petition.
Correct.
Writ petition has been decided against the writ petitioners.
Writ petitioner.
And
the issue has been decided.
And writ petition is only on the issue regarding challenge to their appointments. But the other issues,
Lordship,
which you are aggrieved now,
yes, Lordship.
Those issues are presently before us.
Yes, Lordship.
The private, as we have already indicated, the private respondents may not have too much of a say in this present issue before us. But can you exclude somebody who was
See the Lordship, the order of Portem, whether that principle is being, Lordship, interfere or not while proceeding the present appeal without.
But Madam is raising a maintainability issue.
Lordship, I'm raising maintainability in regard to, in writ petition, we have filed affidavit in reply, Your Lordship, in response to affidavit in opposition filed by respondent number 4. That also they have not brought into record. They have not annexed in the appeal, Your
That
Lordship.
is okay. That will have the record.
Lordship.
That is not a problem. That may not amount to suppression.
Lordship.
Suppression is something which the court will not even know later. Now the records will show everything.
Regarding non-implement of
Ground for, what are the other grounds for questioning maintainability?
only that, Your Lordship, not annexing my affidavit in reply, because in that affidavit in reply, I have shown the honors of proof, Your
That
Lordship.
we'll consider even now.
Lordship.
Records are before us.
Lordship.
The records of the single bench is before us. So
In
you should have given all the consolidated appeal.
I agree.
But for that, we'll not defer the matter. We are only on the first point of erring or not erring requirement.
In that regard, Lordship, I'll not have any objections for not airing the respondents, because the main issue herein is the state is aggrieved of directing them to pay me the minimal pay scale or pay in my presence.
Then you proceed. The
Lordship.
madam is also not having objection. Yes.
Lost.
But was this issue ever discussed? The issue of not arraying the private respondents as party here in the appeal, was it discussed in any
No,
previous point of time?
no,
No discussion.
not this.
Let us see the admission order. It was admitted by which order?
It was by, kindly see 19/3/2024 order laws.
Admitted for hearing.
Oh, laws, kindly 28/2 laws. 20.
No, 5-2.
5-2. By that, I think IA has been
No,
allowed.
no. In view of the order passed in IS so-and-so, appeal is admitted for hearing. That is the order
Laws.
listed in the reports.
Otherwise, I'm ready to implement them, laws, but only
Well, we can hear it. You can hear if there is no strong objection. Yes, you can continue.
laws.
Yes.
Lordship, out of these three issues, Lordship,
Hmm.
one, the
How
first
many issues were formulated?
three issues are formulated, Lordship.
Yes.
The issue number one, Lordship, as per the prayer made in the writ petition, Lordship, the issue number one, Lordship, whether the writ petitioners, their service can be regularized or not, that has been negative by the single bench, Lordship. It gone in our favor, Lordship. Because regularization is governed by a particular recruitment rule. And until that is satisfied, Lordship. And so far, second issue is concerned whether the appointment of the private respondents can be, Lordship, set aside or that can be interfered. And that also has been negative. And it has gone in favor of the government and the private respondent, Lordship. And third issue, Lordship, that has gone against us, Lordship, on which I am before this honor court by present appeal.
What is the third issue?
Whether the petitioner are entitled to minimum scale of pay and allowances like regular LDC oblique LDC cum typist, since they have been discharging the same duty like the regular LDC oblique LDC cum typist on the basis of principle of equal pay for equal work.
Yes.
And precisely, Lordship, my Lordship contention is that, Lordship. Here, Lordship will find in this, while framing this particular issue, Lordship, because it was not formulated earlier, Lordship. At the time of passing judgment only it has been formulated, Lordship. Here, Lordship, conclusion has been drawn. Whether the petitioner entitled to minimum scale of pay and allowances like regular LDC oblique LDC cum typist, since they have been discharging the same duty like the regular LDC so and so and so. And whether they are discharging the same like duty and with same volume of work or same Lordship, whether they are having same qualification and all, Lordship. Those aspects, how it it has been lordship dealt by the writ petitioner in his pleading lordship. In their pleading lordship, just I'd like to read two paragraphs from the writ petition. How this area has been lordship touched by the writ petitioner.
Okay, please.
It's page 63 lordship.
63.
63 lordship. And it's part of the writ petition. And writ petition starts from the page lordship 49 lordship. It starts from page 49 and relevant is page 63 lordship. Paragraph 11. May I read lordship this particular paragraph?
At
Page 63 lordship. Paragraph 11.
Just a minute.
This particular annexation lordship, the copy of writ petition. It starts from page
33. What was the number writ petition? 33.
This is 33 laws. Correct.
WPC 33.
WPC 33 laws. 2021.
At 63.
Page 63, paragraph 11 laws.
Yes, please.
The petitioner begs to state that since they are performing the duty of a regular LDC typist / computer operator, they are entitled to equal pay for equal works of regular employees and employees' pay and other remunerations and emoluments and other service benefits is entitled to regular employees. They have been time and again demanded justice. Only this part, the rest are just no lordship, the details lordship, nature of works. There's no specific about the nature of works they are performing lordship. These are the past paragraph lordship, the past paragraph. Only.
What more is required? First line.
Lordship.
Petitioners beg to state that since they are performing the duty of a regular LDC typist / computer operator, they are entitled to equal pay for equal work and other remuneration.
And so far, and second lordship, paragraph 13.
So what is your response to it?
I'm coming lordship. Next paragraph, kindly see the next page, page 64 lordship.
64, 12.
Paragraph 13.
13.
The petitioner begs to state that even if their services are not regular, they are entitled to service benefit regular employees of typists / LDC comes and so. These are the two statements which have been made in the writ petition lordship. So far, equal pay for equal works is concerned lordship.
Yes.
Lordship, how it has been responded by us, lordship, in our affidavit. Lordship, kindly come to page 133, Lordship. Annexure 5.
That is your affidavit.
My affidavit, Lordship. Page 133, Annexure 5, Lordship. I'm taking Lordship to the paragraph 7, Lordship.
Page?
Page 133, Lordship.
No, the annexure, page
133, Lordship.
133 is the affidavit.
Affidavit, Lordship.
Now, which paragraph?
Paragraph at page 138, Lordship. Paragraph 7.
138.
138.
Yes, please.
I'd like to read paragraph 7, 8, Lordship. 7 and 8.
Yes.
The answering response begs to state that the engagement of casual / contingency employees are made only for work which is casual and which is not full-time in nature. They are interested to do the minimum amount of work with lesser responsibility so far as casual oblique contingency employees working at office is concerned. The answering response begs to state that there is no post of regular computer operator created in a department. Hence, such regular post does not exist. So far computer operator is concerned, there is no regular post in the department. As far as the post of regular LDC is concerned, appointment oblique regulations are made in accordance with the provisions under so and so. There is a provision in the recruitment rule of LDC that 15% of the vacancies are to be recruited through limited departmental competitive examination from amongst skilled contingency oblique casual employees. The said vacancies had already been filled up by the department as illustrated below. Then I'm taking lawsuit to the paragraph 9 also. Paragraph 9. Paragraph 9, but I'm taking lawsuit to the second paragraph of the paragraph 9, which is at page 142. Page 140. Also.
That there is.
Yes, sir. There's no shortage of LDC, oblique UDC, and Group D MCs where the petition have been posted. Their nature of work, nature of duty is to help the regular staff, not engage oblique employed instead of regular staff. They have not dealt any file as done by the regular staff. Hence, it's false to claim this they perform the same duty and same work of LDC lawsuit.
So what were their designation?
As I have submitted lawsuit, so far typist is concerned lawsuit. Typist, one was the manual typing, earlier it was their lawsuit. For lawsuit, as on today, that part is not available in the office lawsuit. Now lawsuit, the computer operator is their lawsuit. And LDC is the lower clerk division is their lawsuit. Here, as I have submitted lawsuit, earlier some were appointed as a typist lawsuit.
Which year?
Different dates are here lawsuit.
So 2, 4, and 7 were appointed as typists, you have said.
Lawsuit.
Which year?
Here lawsuit, kindly come to paragraph 2 of my appeal lawsuit.
Yes.
Page 9 lawsuit.
Yes.
Page 9 lawsuit.
Page 9, yes.
Paragraph 2 lawsuit.
Yes, please.
This one, the petitioner number 1.
Yes, 1 and 6. 1 is in 1996.
96. And petitioner number 2, contingency peon, 1997 lawsuit. Petition number 3.
Now, petition number 2, 4, and 7, you said that they have been working as typists.
Typist lawsuit.
But here you have written contingency peon. I think you are 3 is a casual typist. I think it should be 3.
This peon.
2.
Not 2, 4, and 7.
Lawsuit, one petitioner during the course of hearing of the writ petition lawsuit, one petitioner, I think he was already given the double C lawsuit. Therefore, name was omitted. Therefore, there's changes of the petitioner number lawsuit. Otherwise, lawsuit can see their names reflected in the writ petition lawsuit, cost title of the writ petition lawsuit.
Okay. So how many, initially, how many writ petitioners were there?
There were eight writ petitioners.
Now, 1 has been given.
One has been given.
So in the appeal, you have filed against 7.
7.
So there is reduction by one. One, I think, which number had gone?
Petitioner number one.
Petitioner number one.
One had got the benefit.
Yes, Lordship. That is prior to Lordship final hearing of the read petition.
Okay, doesn't matter. But initially, he was one of the petitioners.
He was a petition number one.
One.
So since her name has been Lordship omitted,
Sure.
therefore numbers have Lordship.
Okay.
However, I have given the name. here.
Just a minute. So LDCs are actually petitioners numbers 2 and 7. In your appeal, the
Hello.
description of 1 and 6 are actually petitioners number 2 and 7. And typist would be 3, 5, and 8. And computer operator would be 6 and 9.
Not 9, Lordship.
Cannot be say. You had said 5 and 8 are computer operators. How can it be 8?
Earlier, Lordship, the read petitioner 1 has become now petitioner number, private respondent number. 2 become 1, 3 become 2, and 4 become 3.
Yes.
Likewise, Lordship, up to earlier, it's up to 8, Lordship. The 8 become 7 here, Lordship.
Okay. Yes, next. Yes, please proceed.
So, Lordship, that is the Lordship stand taken by the our state Lordship. So, responding this particular Lordship. Now, what I would like to point out here, Lordship. So, for the parity is concerned, Lordship. The aspect of parity has to be examined in details, Lordship.
Yes.
Their nature of Lordship qualifications, how selections were done is okay, but their qualification, Lordship.
Yes.
Then nature of works, Lordship, being performed by them, Lordship. The nature of responsibilities they are burdened with, Lordship. And the same, Lordship, whether these nature of works are equal to that of the Lordship, the regular employees who are there already or not, Lordship. In this respect, Lordship, what learned single bench has directed is to provide a pay scale, Lordship. But Lordship will find in Uma Devi and Jagdish Singh, Lordship, it talks about the wages equal to the minimum pay scale of that particular, not the pay scale, but the wages equal to the pay scale of the
minimum pay scale.
Minimum pay scale of the that particular cadre, Lordship. But what direction has been given in the present judgment, Lordship, in judgment, to provide the pay scale of, which is not, to my understanding, in terms of the Jagdish Singh and Uma Devi case. There's the one aspect, Lordship, which I'm contending before the Sonal Court. And second is, Lordship, those aspects have not been examined by the learned single bench, Lordship. To arrive at a conclusion, Lordship, they are in equal footing so far their works, everything are concerned, Lordship. Except for selection process, Lordship. Rest they are similar and same, Lordship. That aspect has not been examined by the learned single bench, Lordship. So my submission is the Lordship, to arrive at that conclusion, Lordship, that examination must be there, preceded, that examination must be preceded to the Lordship conclusion, Lordship, which the learned single bench has not done, Lordship. Otherwise, Lordship, everything. There's the one aspect, Lordship. Then so far, if I take Lordship to the impugned judgment itself, Lordship. Kindly come to page 36, Lordship. It's a part of the impugned judgment only. Few paragraphs of the Jagjit Singh case has been quoted by the London Single Bench, Lordship.
Yes.
Lordship, see, paragraph 24, Lordship. Impugned judgment starts from page 20, Lordship, Annexure 1.
Page 20, it starts.
It starts from page 20, Annexure 1, Lordship. This is the impugned judgment, Lordship. The principle laid down in Umadevi and
But
Jagjit Singh.
the direction is for giving minimum pay scale.
Lordship.
You had made your, what we have understood.
Lordship.
There are certain factors to come to a conclusion, their parity.
Parity.
Including qualification, nature of work, responsibility of the work, amongst others.
Lordship.
You say that there is no discussion on this.
No
The
discussion.
second part, you have said that Umadevi and Jagjit has directed for paying the minimum of pay scale.
A minimum of the wages equal to the minimum the minimum pay scale of the regular employee, Lordship.
So how does it make a difference?
One
If
is the Lordship without rest benefits, Lordship.
yes,
Only the amount, particular amount is given, Lordship. So for the regular employee is concerned, Lordship. By
let us see Jagjit, what has been quoted at page 36.
page 36, kindly see the paragraph 24, Lordship. Page 36,
Yes.
paragraph 24, Lordship. May I read, Lordship, paragraph 42?
Yes.
All the judgments noticed in the para 7 to 24 here and above pertain to employees engaged on regular basis who were claiming higher wages under the principle of equal pay for equal work. The claim raised by such employees was premised on the ground that the duty and responsibilities rendered by them were against the same post for which a higher pay scale was being allowed in other government department. Or alternatively, their duties and responsibilities were the same as of other posts with the different designation. But they were placed in a lower scale. Having been painstakingly taken through the parameters laid down by this court, wherein the principle of equal pay for equal work was invoked and considered, it would be just and appropriate to delineate the parameters laid down by this court. In recording the said parameters, we have also adverted to some other judgment pertaining to temporary employees also dealt with in the instant judgment, wherein this court had occasion to express the legal positions with reference to the principle of equal pay for equal works. Our consideration has led us to the following deductions. The onus of proof of parity in the duties and responsibility of the subject post with the reference post under the principle of equal pay for equal work lies on the person.
Rapin, we have more or less had a glance of this. These are all quotation of Jagjit Singh.
Lordship.
Where is that part that while Jagjit talks about providing wages minimum to the pay scale, in the present case, there is a direction for payment of pay scale, minimum pay scale, not wages. You make out the distinction.
Yes. Lordship, yes. Kindly come to page 43, Lordship.
43.
43, Lord. Here, the paragraph 44.6 has been quoted. This is of Uma Devi case, Lordship. The last paragraph, Lordship. The last line, Lordship. If the word component was the same, the judgment rendered by the High Court was modified by this court, and the daily wage employees concerned were directed to be paid wages equal to the salary at the lowest grade of the cadre concerned, Lordship.
Jagjit, this Uma Devi has been approved by Jagjit, last line. You're referring to 43, page 43, 44.6.
Lordship. .6 is the reference of the Uma Devi case only, Lordship.
Now, what is the direction here in this case?
In this case, kindly
Page
come
30.
to paragraph
Paragraph 30.
30, Lordship.
Attended
As
by-
discussed here, that the opposite contention of the petitioner have not been seriously disputed by so and so. Having considered the submissions of the learned advocates of both sides, and also drawing premises from the propositions of law so laid down in Jagjit Singh Supra and Uma Devi, this court is of the consider opinion that the petitioner are entitled to at least minimum scale of pay in their present position, based on the principle of equal pay for equal works. Accordingly, this provided SSL provide minimum pay scale. Once the scale is
Do
provided,
you have Upendas with you?
Opendas is I just left.
Madam, you have Upendas with you?
No, Your Lordship.
Get Upendas.
I have noted here, but
WA 45 of 11.
state of Assam, this Opendas is.
Madam, when it's Upendas is reported. WA 45 of 2011, please give a copy.
2025 GMT.
Upendas. Not ready to citation to.
And other lawsuit, so far lawsuit, the computer operator and the peon is concerned lawsuit. Direction is lawsuit has seen lawsuit. Here, direction is
But how long they are in service, madam?
Some are more than 28 years and others more than 18 years, Your Lordship.
Mr. Tapin, at times, you need to be considerate. This is the minimum.
They have spent a
Why are
prime
we making
age, Your Lordship, in the
such a
department.
big issue?
lawsuit.
18 years, 20 years, they are serving.
Lawsuit,
Nobody has not said regularize them. You give them a minimum pay scale, whether it's, you call it wages. How does it make a difference?
lawsuit, as a matter of lawsuit, because this being High Court being the court of record lawsuit, President's lawsuit, always their lawsuit. Therefore, lawsuit, the certain principle has to be lawsuit followed, and at
High
least
Court has followed Uma Devi, High Court has followed Jagjit Singh, High Court has followed Umar Upendas.
but present fact and circumstances lawsuit, the background of the petitioners, whether that fit with the lawsuit, that principle laid in that two cases or not. At least that aspect should have been lawsuit.
See, what they had prayed for, that was not granted.
Lawsuit.
In fact, setting aside the petition, appointment of some respondents, whether you allow or not allow, it's not going to give the benefit to the petitioners. So that let us not talk about that issue.
Lordship.
There are three issues which you have rightly pointed out. Number one, whether the petitioner can be regularized. No,
No.
they are not aggrieved.
Lordship.
Second issue, whether private respondents' appointment can be interfered with. No, not aggrieved. Now, only the third, to give the minimum scale of pay. You are trying to bring a fine distinction that it has to be wages, which which can first, and number two, there is no determination of the factors of equality of work, responsibility, so that these principles can be applicable.
Lordship.
And the third is, which I've just pointed out, that there would be some other ramification if it is in the nature of giving the pay scale.
Lordship. Lordship, giving wages as a lordship one fixed amount, lordship, which is equal to minimum pay scale of the regular employee, is one thing, lordship. But providing a scale, lordship, it follows something else, lordship, because some other.
Let us see Upendra's. Madam. Okay. Oh, it one is.
And one aspect also, there's no computer operator regular post in the department. Those also aspect also has not been considered, lordship. Even there's no whisper on that issue, lordship.
Upendra's will go against you. Upendra's the last paragraph. Of course, the first part was on a concession made by the state. If you have read Upendra's carefully, we are just reading it for you. See, the challenge of the petitioners, which was allowed by the single judge, the claim for regularization, which was allowed by the single judge, was interfered by the division bench. The state's appeal was allowed. The aspect of regulation was negated. But in paragraph 22, penultimate paragraph, something else is there. It is, however, heartening to learn that the state government has agreed not to terminate the master roll, work charge, and similarly placed employees working since last more than 10 years, not in sanction post, till their normal retirement, except on disciplinary ground or on ground of criminal offense. The state has also agreed to enlist such employees in health and accidental and death insurance scheme, which will be prepared in consultation with the state cabinet. These are all concessions. It will not have a binding effect on.
Yes.
Okay. We appreciate this positive stand of the state government taken as welfare measures for the betterment and security of the employees in question. We accordingly direct the state government to implement the measures without further delay. That is the concession. Now this.
Yes.
Besides this, we, in the light of the decision of the Supreme Court in Jagjit Singh, also direct the state government to pay minimum of the pay scale to the master roll, work charge, and similarly placed employees working for the last more than 10 years, not in sanction post, with effect from such and such date, the date of the judgment.
In Jagjit Singh case also, the minimum wages is, I think.
Let us see. Jagjit has been quoted.
It has been
but
quoted.
Jagjit was considered by the division bench in Upendra's. It's only the minimum of the pay scale you are paying them, nothing else. We can clarify that. They will not be entitled to any regulation or anything. In fact, those have been negated by the Honorable Single Bench, not put to challenge by them, though those directions have attained finality.
Lordship, I'm sorry,
And,
Lordship, I'm not.
The length, duration was, standard was taken to be 10 years or more. Here it's 18 years, 20 years.
That part is okay, but one only non-considerations of the lordship that contention of the state government, and secondly, lordship, judging actually last night lately I came back from Zero, so therefore this particular judgment, Uma Devi and Jagdish Singh, these are the two judgments.
Both have been considered by Upendas.
So just my only reservation is that lordship, whether this judgment giving the pay scale is in consonance with the principle laid down in these two judgments or not.
Those have been considered and this has been given. It's not that
because
Jagdish was ignored.
Because these two judgments, lordship, it talks about the wages equal to lordship, the pay scale, minimum pay scale.
No, there are two. You have very fairly shown the pleadings in the repetition in 2 paragraphs. I think those are enough. It cannot be too detailed. And unless there is a categorical denial by you. There is no categorical denial. You said that the work which they are doing cannot be equated with the work done by a regular person. It's a universal fact. A casual employee cannot, their work cannot be said to be as the responsibility or the nature of duties cannot be said to be equal. But the length of service, their expectation of somebody in public service. Regulation aspect has been denied. Nothing to do. There is not under challenge. Challenge to the private respondents that has been denied, not challenged. Only aspect of minimum wage. I think this is something in furtherance of having a welfare state.
So may I pray, lordship, only on this issue, and one more issue is there, lordship. Now, lordship, we have our own policy, lordship. In that particular policy, the maximum who has rendered 20 years, they are being paid, lordship, 24,000. And those who have rendered some, is the length of their service, lordship. We are paying up to 30,000, lordship. This is our policy, lordship.
Policy came when?
2019.
But why wasn't this policy brought to the notice of the Honorable Single Judge?
Actually, that was not brought before because.
Then you file a review. If you have a policy specifically for the state to give them something which you think is justified towards the prayer, on that point you can file a review.
Actually, I came to know about that notification, lordship.
Then,
in connection to another.
It was an existing condition.
Even
review will not lie.
Latest should be 2025 only. Latest policy, 2025, not 19, I think.
It has been 22, then again it has been reviewed.
What
periodically it's used to.
The policy started when?
Policy that I have to seal because in connection to another lawsuit petition.
See, there will be various issues as well as complications.
No, what
I'm trying to judgment was rendered, whether the policy was there, number one. If it was there, what prevented you from bringing it to the notice of the court? That means there was no performance of due diligence. Now, can it be a ground of review? There was no due diligence.
Lawsuit, what I'm trying to point out is lawsuit. Here, the minimum wages, pay scale of the particular case, it may go below the wages we are paying now, lawsuit. That may happen, lawsuit. Therefore, this aspect, lawsuit, on Friday, it may be taken up only for this issue. Because lawsuit, if direct the minimum pay scale, lawsuit, if allow, but we are paying more than the lawsuit minimum.
We'll clarify that. Whichever is higher will pay. We'll clarify that. They should not suffer prejudice. If you are giving something more than the minimum scale, they should not suffer prejudice.
Lawsuit.
By a judgment.
Otherwise, at 2, only for this aspect, lawsuit.
I'll clock whether we are DB.
I'll come with that notification, lawsuit.
Maybe tomorrow.
Tomorrow you are there or not?
Tomorrow I am not there. On Friday it can be taken.
Friday is difficult. Friday.
Only this is small.
Oh, at 2 o'clock we can resume. We can.
Only for this loss.
2 o'clock, madam.
2 o'clock.
It may not be required to hear you in details. We have indicated what we are trying to. Okay. Only for that issue, Mr.
Yes,
Captain.
boss.
Otherwise,
Yes.
we have made our mind very clear.
Close.
Obliged.
Is this the last matter?
Yes, Lordship.
But 2 o'clock we'll sit, we will sit for some time, okay? Now, within 5 minutes, we'll have the single bench.
Pronouncement of judgment of item number 1 to 4.
The draft, there's a withdrawn, give it to them with some corrections.
In view of the aforesaid facts and circumstances and the discussions made, while WPC 284/2025 is dismissed, the other petitions, namely 14 of 2022, 459 of 2022, and 295 of 2024 are disposed of by directing the government in the hydropower department to conclude the exercise initiated by the order dated 35/2025 by considering the representation of the officers employees of the department expeditiously and preferably within a period of 3 months from the date of receipt of a certified copy of this order, to make the exercise a consolidated one. If any further representations are to be submitted by any aggrieved persons on the issue, liberty is granted to do so within a period of 10 days from today. It is needless to state that in the exercise to be conducted, the representationists shall be given an opportunity of hearing. After such consideration, the department is required to pass a speaking order, which is required to be communicated to all the parties. Interim order operating stands merged with the final orders. Yes, Mr. Patil.
Malat, hopefully, item number 24 and 25 hearing list, Malat, should be taken up before rising of the single bench. Lunch break, Malat. Otherwise, Malat, there is some urgency. May I pray that this may be taken up as a first item after the rising of the division bench at 2 o'clock.
Hearing will come at hearing only. There are many admission matters, motion matters. In the hearing column, we can take your matter as the first item. Yeah, but yours is the first item only.
Yes.
23 matters have to be over.
But I already
We
prepared.
cannot assure you. And 2 o'clock, the DB will be there. Maybe we may reserve the judgment. It may not take too much time. But we should reach, ready for we should reach. Let us see. If there is some difficulty, then we'll not now, at that time, we'll fix a date of your convenience. What is the matter about?
Well, this is regarding acquisition of land.
I'm from Union of India, my lord. Actually, we want to get it disposed of early, my lord.
Okay.
So
No, Mr. Doloi and Mr. Patil, just so we'll try to have the matter. Okay.
Yes, I beg to mention item 23, my lord.
23.
My lord. Here I am for private respondent number 7, my lord. I'm praying some time, 2 week time, my lord, to file a counter epidemic, my lord. I have informed the other side.
Okay. Here for R7.
R7, my lord.
3. L. Perme, learned counsel for respondent number 7. Prays for and is granted 3 weeks time to file affidavit in opposition.
Well.
List after 3 weeks.
Oh, yes, well.
Yes.
Item number 5.
Yes, madam, what is this?
Yes, Your Lordship, on the last occasion, the respondent has sought time to take the instruction, Your Lord.
Yes, Lordship, I have the instruction, Lordship.
What is the matter about?
Matter is, to dispose of my representation, Your Lord.
And Lordship, as per the instruction, Lordship, this representation has been disposed of, Lordship.
When you withdraw this, we'll give you, if you're aggrieved by the disposal order, you can challenge.
Yes, Your Lord.
Okay, and what is your name, madam?
Tirimi.
Heard Miss T. Rimi,
Yes, Your Lord.
Learned Counsel for the petitioner. Also heard your name?
K lawyer, Lordship.
Okay, lawyer for whom?
Respondent 1 to 5, Lordship. Union of India, Lordship.
You are a CCC?
Yes, Lordship.
Learned CCC for the CCC as well as Miss so Learned State Council. Miss Basar, huh? State Council. Para? Considering the subject matter and also taking into consideration the written instructions placed on record by the learned CDC, the instant writ petition is taken up for disposal at the motion stage itself.
Yes.
Full stop. Suffice it to mention that this matter was taken up for consideration on 3 previous occasions when directions were given to the learned CDC to obtain the necessary instructions. Para? Please have your seat. The primary grievance raised in this petition is with regard to non-consideration of our representation, which has been stated to be submitted on 18/3/2025, full stop. The said representation was with regard to the acquisition of 19 acres of land for the establishment of the 340 Field Regiment at Galemo under the Limking LIMK, Limking Circle of the Upper Subansiri district of the state. Full stop. Para? As mentioned above, comma, directions were issued by this court to the learned CDC to obtain instructions on the FAT of the representation. Full stop. Para? 3 lawyer, the learned CDC has placed on record that record a copy of written instructions dated 9/2/2026, as per which the representation of the petitioner has been disposed of. Full stop. Para? The order of such disposal, however, has not been enclosed to the written instructions. Full stop. The respondents, the instant writ petition is accordingly disposed of by directing the respondents to communicate the order of disposal of the representation, the order by which the representation was disposed of, so that the petitioner, comma, if aggrieved, can raise a fresh challenge. Full stop. Para? With the aforesaid observation, the writ petition stands disposed of. Para? Copy of the written instructions dated 9/2/2026 is made part of the records. Mr. Lawyer, it doesn't seem that there is there's an order, only an observation.
Yes, Your
So
Lordship.
just instruct your client.
Serial number 5, Lordship.
5, just read again.
That the petitioner, Mr. Takok Mara, son of so-and-so, has asked for the compensation for his land, which is under progress with competent authorities. His representation is hereby
disposed of. By a letter written to you, his representation cannot be disposed of. Ask your officers to, this is not the way. Representation cannot be disposed of by writing a letter to you. Representation has to be disposed of first by a speaking order. Number 2, all the factors have to be considered. And number 3, most important, is to be communicated to the affected party. This may be a good reason that it is under consideration of the competent authority. But this reason has to be recorded and send to the party. So
I'll
that is what-
convey this lawsuit.
You please, that is a part of the order, in fact, okay?
Proceed. Deeply obliged.
Item number 6.
Yeah, my lord. My lord, this matter regarding to for realization of amount of 36,17,992 from the respondent authorities for the consultancy fees relating to the DPR for 46 kilometer Bimlapur to Longding Road under NEC funding, Your Honor.
So where is there any acknowledgement of liability?
Yes, Your Honor.
Is there any acknowledgement of the liability by the respondents?
Yes,
Where, which page?
Your Honor, come to the page number 28.
28.
Yes.
Yes, please.
It's Annex 3.
Yes.
Here the executive engineer. Here the executive engineer has formally given me a work order detailing survey, investigation and prepare for drafting of DPR and Bimlapur Longding under NEC.
What is your name?
T. Taggu.
Hmm?
T. Taggu.
Mr. Tagu, there is a requirement of there being an acknowledgement of the liability in writing by the head of the department chief engineer as per a full bench. Where is the liability in writing? See, you have come to a writ court. We are not a court on facts.
Yes.
Once there are questions of fact and those are disputed, it is not even maintainable. If it is not disputed, then at least you have to discharge your obligation, prove it. You cannot prove something before a writ court without adducing evidence. That facility will have in the civil court. But there's an exception by the full bench that if there is an acknowledgement of the liability by the head of the department, we can still entertain your writ petition. Is there any communication, any
Yes, Your Honor. There.
from where something can be deciphered that there is an acknowledgement of the liability?
Your Honor, come to page number 39. Annex, yes, Annex 11.
Yes, please.
This was a reminder notice by the chief engineer to the executive engineer for releasing of payment. Your Honor.
Please read 39 where, please.
Annex 11.
Yes.
Office of the chief engineer.
Yes, yes.
Subject to the executive engineer, Kanabari Division, PWD, AP.
No, this is written not by the chief engineer. It is by surveyor works. He's not the chief engineer, but nonetheless, please read the contents.
Release of consultancy fees.
That is the subject.
Against detailed survey in preparation for.
That is the subject. Please read the contents.
Kindly refer to the above quoted letter number so and so. On the said subject, you are once again requested to furnish the detailed background of the above work along with all relevant correspondence made on this issue, which your comments and recommendation on the request of the consultancy firm and for further necessary action of this office.
She was directed to furnish the detailed background. Not this is not a liability. Where is the liability? These are all your notices. Thereafter.
Yes. Good question.
Okay, madam, we do not know the fate of this. At this stage, let us issue a notice.
Yes.
Heard Sri T. Taggu, Learned Counsel for the petitioner who has approached this court for a direction for release of contractual dues pertaining to preparation of a DPR. Full stop. The said claim is for consultancy fees for preparation of the DPR for 46 km Bimalapur Longding Road under the NEC funding. Full stop. The Learned Council has drawn the attention of this court to various communication on the aspect of the said tendency, on the aspect of non-release of the non-release of the amount in question. Full stop. Though, as per the Honorable Full Bench of this court, in the case of Ramsar Ali versus State of Assam reported in so-and-so, there is a requirement of an admission of the liability in writing by the Chief Engineer of the head of the department, there is no specific acknowledgement of liability in the instant case. However, there are certain communications from which the aspect can be deciphered. In view of the above, let notice be issued, returnable by 6 weeks. Miss Wangmo?
Yes.
Ms. Wangmo, for all, madam?
Yes.
Then the State Council accepts notice on behalf of all the respondents. That extra copies be served upon her by tomorrow. We can give you a returnable date. List on 25th of March.
Okay. Much obliged.
Item number 7.
Yes, and my lord, we are WSO, my lord, WSO, Health and Wellness Officer, my lord, serving under National Health Mission, my lord. Now, private respondents, my lord, are also presently serving as WSO, my lord, but they are entry, my lord.
What is the full form? W?
HWO, my lord.
What is HW?
Health and Wellness Officers, my lord.
Health
and Wellness Officers.
And Wellness?
Wellness, my lord.
Officer?
Officers, my lord.
HWO.
My lord.
Okay, you are the HWO, the private respondents are also HWO.
HWO, but our entry to the HWO to direct, my lord, they come to as a past day recruited as a nursing officer, my lord. Nursing officer, my lord. Nursing officer.
It is from nursing officer.
No, not exactly promotion, my lord. They also, while they are serving in the NO, my lord, they also later on participate in that WSO exam, my lord. Accordingly, they is recruited.
The exam was a common one.
No, my lord. NO different, my lord. WSO.
No, exam to be inducted as HWO was a common exam.
Common exam, my lord.
So,
in occasion also earlier in earlier point of time, my lord, even they were given preference, my lord. This NO serving NO were given preference in that post, my lord.
Yes.
We are direct, my lord. Now I'm impugning the seniority list, my lord, because my seniority list, my lord. In seniority list, my lord, the seniority list, my lord, is maintained in WSO seniority list, my lord. Now their service, my lord, private respondent service is NO is also being counted, my lord. Where is, my lord, NO is a WSO different post, my lord, different pay salary, my lord. Now in impugn seniority list, my lord, suppose, my lord, example, my lord, we petitioner, my lord, so recruiting 20 as a NO, my lord. Oh, sorry, my WSO, my lord.
Now tell us one thing, Mr. Parme. In the common selection test,
my lord,
for being inducted,
my lord,
as an HWO,
my lord,
a merit list is prepared?
Yes, my lord.
Merit list is prepared?
My lord.
And in that merit list, there can be somebody like you who are directly appointed as the HWO. And there are persons who were earlier working as nursing officer.
Nursing officer, my lord.
But both of them had to compete in a common exam.
A common exam, my lord.
Now, in the seniority list which has been prepared,
My lord.
you are contending that the persons who were nursing officers
My lord.
and had participated in this selection, their seniority as a nursing officer has also been counted
My lord.
and been put above you.
Yeah, my lord.
Okay.
That the issue, my lord.
Okay.
So example, my lord, suppose we are recruit of 2020, my lord. Now the NO, my lord, who later on participate in 2021 exam, my lord, become also senior to us, my lord. Because they are serving as a NO in 2019, my lord.
Okay, Mr. Tagum, Health Department.
My lord.
This probably would not be a fair exercise.
My
Unless you make out, see, there are different avenues. So
My lord.
suppose a particular post is filled up by promotion as well as by direct recruitment.
Yes.
There can be a tussle, which this morning judgment was involving those only, who will be senior. Now here is a case, you can enter as a direct, as a direct, and even the NO will be a direct recruitee.
My lord.
Not by virtue of promotion. He competes in the same
Yes, my
examination.
lord.
If he competes in the same examination,
The same yardstick.
it will be only on the position in the merit list, in the selection that will govern the seniority,
Right.
unless age is a factor.
My lord. That's
If they are the same position, then the older in age will be senior.
my lord.
If one is above in the merit list, he will be treated as senior. Now, one NO who has been inducted in as WHO, even after the present petitioner, how can you treat him to be senior in the cadre of WHO?
Yes, my lord.
HW.
My lord, that part, my lord, I have to take instructed,
Okay.
my lord.
Third, 3L Perme, Learned Council for the petitioners. Full stop. The petitioners who are working as health and wellness officers in the Department of Health and Family Welfare,
No, my lord.
Under National Health Mission.
under the National Health Mission, are aggrieved by the assignment of seniority
My lord.
in the seniority list dated 27/11/2024. Full stop. It is the case of the petitioner that to enter into the services of HWO, even the nursing officers are entitled to compete. Full stop. However, nursing officers who have been subsequently inducted in the post of HWO have been assigned seniority above the petitioner in spite of the petitioners entering into the said cadre ahead of time. Full stop. The reason cited is that the length of service of the nursing officer have also been taken into consideration. Full stop. Para. Let notice be issued, returnable by 6 weeks. 3 T. Tagum, Learned Standing Council, Health and NHM. NHM.
My lord, Health and Family Welfare.
Health and Family Welfare. You but will be accepting for 1, 2, 3.
Yes, my 1, 2, 3.
One accept notice on behalf of respondents 1, 2, 3. Let extra copies be served upon him by tomorrow. Let steps be taken for service of notice upon the respondent 4 to 32 by speed post with ED. Steps within 2 working days. Full stop. Para. 3. Permit the Learned Council prays for an interim order. Full stop. Para. While a seniority list, while the aspect of staying a seniority list cannot arise, it is provided that no further promotions or be made from the impugned seniority list till the returnable date. What is the next promotion post?
It's not for regularization, my lord. We are contracted.
No further action of any regularization. Oh, don't say promotion, huh? Be taken for the impugned seniority.
High levels, man.
You resolve this issue.
My lord.
Some mistake, I think, is next.
Item number 8.
May I submit, my lord? And in this case, my lord, I am impugning, my lord, selection of my lord of private respondent, my lord, as a Gram chairperson, my lord, of
ground?
Gram chairperson, my lord.
On the ground?
On the my lord, what happened in this case, my lord? In my lord, 2 Paunung Gram Panchayat, my lord.
First, you tell us who are you?
I'm, my lord, one of the candidate, my lord.
You are a candidate.
Candidate, my lord. My lord, what happened in this case? There in Paunung Gram Panchayat, my lord, there is 3 GPM, my lord. 3 GPM, my lord. Two is independent, my lord. Both the petitioner, my lord. One is proposer and petitioner number 1 is a candidate.
When was this selection made?
Selection made, my lord, on 10/1/2026, my lord.
10-1. Okay, we'll issue notice, Mr. Tapan. Third, 3L permit. Learned counsel for the petitioners. First, as per the facts projected, the petitioners are duly elected Gram Panchayat members and were aspirant for the post of the chairperson. Full stop. However, the respondent number 5 has been elected to the said post in an illegal manner. Full stop. What are your grounds?
Ground, my lord, out of 3, my lord, we are 2, my lord. We are the majority, my lord. But though my name as a candidate is notified, my lord, but arbitrarily, my lord, saying that I'm independent candidate, so I cannot contest for the GPM, my lord. He was
Has been illegal. Okay. Let notice be issued. Returnable on. We put a date. Returnable on 16th of March. Not 16th. We can have it on 13th of March. 13th of March. 3S Tapin, learned senior advocate at Arunachal accepts notice on behalf of 1, 3, and 4. Madam Anju and Anju for 2 extra copies. 5 by speed post with AD within 2 working days. Okay.
I humbly, my lord, the record may be corporate in this case, my lord. Record, they are not probably RTF. I believe.
On the returnable date, the Learned State Council would also obtain the records.
High level.
Item number 9.
Yes.
Yeah, may I please, Your Lordship? Here, this writ petition is filed, being aggrieved by the impugned transfer order dated 1/2/2026. So here, Lordship, brief fact of the case is that I have rendered more than 25 years of service. It is only in the recent past, that is on 3/2, that is 3rd February 2025, I was transferred from other branch, that is department, to the education department. And while
what is your post?
Lordship?
What is your post? You are posted as what?
SO, section officer, yes.
Petitioner is a section officer.
Yes. So here, Lordship, I was on 3rd February 2025, I was first transfer, that is in the recent past, in the education department from other department, and I joined the department, and I have been performing the duty. And on 6/2/2025, again, within a period of 2 days, 3 days.
6/2/25.
Yes, 6/2/25. That is the second transfer order which has been issued. Within a period of 3 days, that transfer order has been issued. And to that effect, I have voiced my right why I have been harassed in such a manner. Then thereafter, what happened?
Did you, Mr. Boy, did you actually join after 3/2?
Yes, definitely. I have joined and I have been functioning.
Within 2 days?
Yes.
So for
on the same day I have joined.
You were transferred to the education department from where?
From other department.
But in the same place?
No, from
This office is, where is the office?
actually my job is within Arunachal Pradesh Civil Secretariat. And my job is not transferable to other department.
Okay.
Of course, within secretariat, that is there.
So on 3rd, you had joined.
Yes.
And on 6th, again, you were transferred to where?
Again, I have been transferred from this education branch to then lottery branch.
To?
Lottery branch.
Lottery branch.
Lottery branch.
Okay, then?
Then thereafter, I have joined my duty on 7/2/2025, 7 February 2025. I joined.
In the lottery branch?
Yes.
Then-
And Then thereafter, Lordship, I have been rendering my dedicated service sincerely without any adverse remark from any corner
Okay,
to the satisfaction of the competent authority.
okay.
Then thereafter, within a period of that is 11 months, 25 days, again, impugn transfer order which I am being aggrieved.
1-2.
1 to
Transfer
2020.
to where?
Yes, transfer from education department
Not
to
education, from lottery.
lottery.
You're already in lottery now.
Yes, notary. From notary to science and technology department, which is out of civil secretariat, Lordship.
Page.
Yes, may I take your Lordship at the page, that is page from 16, 17, and the type copy is 18.
Where are you?
I find my number at serial number 30, page 19.
30.
Page 30, page 29, Lordship, Annexure C, page 19, sorry.
Yes.
Page 19, Annexure C.
Serial number 30.
Yes, 330.
Timothy Dume, Typodia.
Yes, Lordship.
Petitioner.
So therefore, Lordship, this impugn order has been issued in the interest of, in order to accommodate respondent number 3, who is accommodated. No doubt, he is also section officer, but he is junior too. And prior to that, he has, the respondent number 3 has been working under my control. He has been working as ASO, and now he has been promoted. But he is junior to me. And on the vested interest to accommodate him, I have been transferred out again from.
He might have been junior to you at one point of time. Now he's in the same cadre. Transfer can be made.
But
that cannot be a factor. You can harp on the issue of the frequency of the transfer.
Yes.
The early transfer.
Yes.
Number 1.
Yes.
Number 2, some Malafadi, so far as the number 3 is concerned, to accommodate him.
Yes.
But this order is a 1-2. Now today is what? 9th.
9th.
What is the position?
Now I have not been released. I am there. I am performing my duty there only. Then it is also to highlight this honorable court that this respondent number T, he on promotion he was ASO, that is assistant section officer. Then he got promotion. Then thereafter on promotion he has been transferred to Arunachal Pradesh Public Service Commission. And without that account has been taken, now this respondent number 3 who is now manipulating. And it is in collusion with the respondent authority, respondent number 3, he is there.
Madam, very strong words against you.
He is actually under order of transfer only.
Your Lordship, in this regard, I need to take instruction, Your Lordship.
Has he joined or not? R3?
R3, first time, Your Lordship, this matter.
No, understood. But it was given, copy was given to you, transfer matters. We will not wait for the court to pass interim orders.
Yes, sir. Interim order not be passed, Your Lordship. I need to take instruction,
If you
Your
don't have the
Lordship.
instruction, why shouldn't we pass interim orders? You could have one telephone call would have been enough. R3 has joined or not?
Okay, yes, Your
Our
Lordship.
petition has been released or not?
Yes, Your Lordship.
Obviously,
Then I will take
London Council
instruction, Your
said that he
Lordship.
is not released. And from 1st till 9th, 8 days have passed.
Your Lordship, then I need to take instruction, Your
You
Lordship.
should have done it before.
Yes,
You have
Your
the
Lordship.
copy with you. We'll issue a short notice, maintain status quo. Okay, maintain status quo. We'll issue a short notice. Or you can have the instructions day after tomorrow.
Okay, Your Lordship.
Wednesday, a single bench, huh? And maintain status quo till then. Okay?
Okay, Your Lordship.
Okay. Your D. Boje.
Yes, sir. All that's
3D Boje Learned Counsel for the petitioner who is aggrieved by an order of transfer dated 1/2/2026, by which he has been transferred from the lottery branch, to the science and technology branch
Yes.
under the Secretary and under the government of Arunachal Pradesh. Full stop. Para. It is projected that apart from the aspect of frequent transfer, which the petitioner is subjected to, comma, the present order of transfer is not done bona fide. Full stop. He has also made a categorical allegation that the respondent number 3 has connived with the officers to pass the impugned order of transfer affecting the petitioner. Full stop. Para. Since Ms. P. Pangu, the Learned State Council, does not have the instructions ready, comma, the matter is deferred for consideration till Wednesday. Please give the date. List for motion
Yes, Lord.
on Wednesday.
Lordship, may I pray that I'll be out of session from today, as I have already submitted my letter of absence till 30 of this month.
30?
Yes, Lordship.
Yeah, Lordship, at 2 then, I will take
Okay,
instruction.
then at 2 o'clock, then we'll can have it at 2 o'clock. 2 o'clock, there is a division bench matter after rising of the DB. We'll have it at 2 o'clock.
Lordship, my problem is that personal problem. I have already taken tickets.
Today?
Yes.
What time?
I'm leaving it after this court only.
What ticket of which? A flight or a car or a train or what ticket?
Lordship, I have to go and attend some problems. Lordship.
Ticket of what? You have taken ticket of what? Private vehicle?
Ticket means that, yes, vehicle is there.
Private vehicle?
Yes.
That can wait for a while. 2 o'clock we'll have your matter. We have a division bench for a small clarification. Because if you are not there day after tomorrow, it may not be proper. 2 o'clock we'll have.
Lordship, since
your colleague will be there. We have heard you. Only for that part. If you have joined, if you are still there, and we are not will direct status quo to be maintained. Okay?
All right.
Don't write this order, okay? We'll have it at 2 o'clock. Where are you going, by the way? Some marriage ceremony?
Now, to my native village.
Marriage ceremony?
Yes.
Yes. We could sense you are so happy. But you have not invited us and the bar members. Okay.
All right.
Item number 10.
May it please your lordship, my lord.
Oh, yes,
my lord, I am audible. Yes, sir. I'm sorry, my lord, I could not be personally present today.
No problem.
But the matter is of 2018. Matter is of 2018, so I thought that I will not seek any adjournment in this matter, my lord. 2018. My lord, is very narrow campus the matter is about. It is about land acquisition matter. My lord, in very short, my lord, if your lordship takes up the writ petition, the factual metrics of this case is that
my lord,
we the
if
landowners.
my London Senior Council is my lord taking up as a hearing matter, my lord, that may not be, my lord. I'll
No,
be
why
requesting
not?
more time, my
My
lord.
lord, I'll tell my lord, why not, my lord? This is a hearing of, is a petitioner, I mean, in this case, 2018. The government
My lord, this is even the 2018 matter. This have been heard several times.
No, I know.
And it will take nearly 2-3 hours, my lord. Even I will take more than 1 hour.
No, let
So
it be.
Fixed
My lord, they
for
doesn't
hearing, my
want,
lord. Some of the
my lord, they
convenient dates as
doesn't
per
want that this
senior
matter should be
council.
heard.
As per the senior council, you fix up for hearing as
No, my lord, I will start the case. My lord, let me start the case.
Because we
my
are
lord.
having
Your lordship will kindly.
Mr. Das, if this matter takes time, we are having a number of matters in the single bench.
My
The
lord,
DB is also.
This
will
will take
also
half.
resume.
I know, my lord, this will take half an hour from my side, my lord, 20-25 minutes. It is a very narrow campus, the matter
I'll
is.
take more than 1 hour, my lord, this matter.
No, so we don't mind taking up the matter. All matters are equally important for us. But
Yes.
there are number of matters in the single bench. Division bench is also not completed. So today, if for admission hearing, it may not be possible. If we,
So let it be
Mr.
fixed up for hearing, my
we
lord.
can have it tomorrow. We can have it
No,
we can have it
my lord.
tomorrow.
Tomorrow, my lord.
Tomorrow?
Yes, tomorrow morning, your lordship can take up the matter. Because tomorrow at 2 o'clock, I have a matter, or tomorrow or day after tomorrow, on Wednesday, my lord. Wednesday? Let it be on Wednesday, my lord.
Tomorrow, why it may not be possible?
Wednesday, my lord.
My lord,
Wednesday, my lord.
there is
Wednesday,
claim,
my lord.
counter claim.
Let it be on Wednesday, my lord.
My lord, there is a claim, counter claim by the both parties, my lord. Now we being the, my lord, district administration, now we have to reaffirm, my lord, exactly, my lord, how many area age on death the army are there occupying, my lord. Because they says, my lord, they're occupying only the pocket of areas, my lord.
But 18 matter, we can.
Yes,
My
my
lord,
lord.
let it come on Wednesday, my lord. Let it come on Wednesday.
So
my lord.
let this matter be, my lord, your lordship admit this matter and fix for hearing any.
Why,
date
my
subject to
learned friend, my learned friend is for government, my lord. He is supporting us, and today he's turning a somersault. The petition.
No, I'm sorry.
One second.
That way, my
One
senior
second.
counsel, my lord,
My lord,
editing me,
one
my lord.
second. I will
I
definitely
will
say.
not appreciate that.
My
my
lord,
I'm not supporting anywhere.
He has to play his role very fairly.
Fairly,
Yes,
If you have a
that's all.
case, he will admit it. If you do not have a case, he'll oppose it.
Yes, my lord, let this matter come on. Let this matter come on Wednesday, my lord. I'll argue this matter on Wednesday.
Wednesday, my lord, having some
Wednesday.
difficulty. Let it be end of this month, my lord.
Why,
Because
my
I am.
lord, why 2018
Because I
we
am-
are suffering, my lord? 2018 we are
Yes, my lord,
suffering,
within
my
this
lord.
month, and nothing will happen with few days. Let it be on
2018.
my lord, heaven will
My lord,
not fall,
please,
my lord.
please see the
End-
order
end
of
of this.
25. My lord, kindly see order of 25, 2025. Please see the order of 25,
No, we have
20.
seen it. It
No,
was
this
fixed on
is-
16/6.
Yes.
16/6.
My lord.
16/6, the bench was not in a position to take up the matter.
Yes.
So we'll do one thing, Mr. Das. The purpose of passing the earlier order on 25 was to bring a matter to an end on the next date. Because
Yes.
it's a matter pending since 18.
2000.
So
Yes.
today it's listed out of context.
Yes.
So we'll do have a fixed date, and on that date there will be no adjournment.
Let it come on Wednesday, my lord. Wednesday. We will do the
Wednesday,
2018,
No,
my
my
lord.
lord, I am having.
2018 matter, my lord. We'll do.
18
My lord,
matter,
if your
within this
lordship,
month,
it is
end of
not
this month, last
inconvenient.
week.
If it is not
For my lord.
Mr. Das, have a date of your convenience or
Yes.
of your consensus?
Yes. yes. Any date in the last week of this month.
Mr. Dolo is there, Mr.
Because my lord, I am having a personal issue. I have to go to Calcutta for checkup, my lord. That is the thing. Otherwise, I won't have objected.
Okay,
End of this month.
then we can have it on 25th.
Yes, my lord.
25th is a Wednesday, but please do not seek any adjournment.
Yes, my lord.
Okay? Not because that Mr. Das is harping on the matter. It's a matter of 2018.
Yes.
This the responsibility of all of us to bring this matter to an end.
Yes.
18 matter.
Yes.
Mr. Mao?
I think
25th, is it okay, Mr. Das?
Okay, my lord. 25.
Okay.
Hope so, Mr. Yadav and Mr. Nabam doesn't take time.
No, I never
Yes.
took time, my lord. It's
Lot
a
of time,
for my
Mr.
issue.
Yadav,
And this is in
my lord will kindly
25th
see.
is the law.
Problem is,
I'm sorry, my lord. One correction
Mr.
to my senior
Yadav,
counsel.
Yadav is
I
not
never
allowing
saw
to speak
adjournment
also.
as on
That's
that,
the
madam.
whole problem.
Okay.
I'm sorry, madam.
Senior counsel who has appeared online and is assisted by Sri S. Mao for the petitioners. Para. One petitioner only, one
Yes.
for the petitioner. Also heard Sri R.H. Nabam, learned AAG, and Sri Y. Doloy, learned counsel for the
Senior panel council for Indian of India.
learned
Senior panel council.
learned senior panel counsel for the Union of India. What's the para? This matter is pending since the year 2018, and there was earlier orders passed for taking up this matter for admission hearing. Full stop. However, para, in view of the above, list for admission hearing. This on 25th of February 2026, on which date an endeavor will be made for disposal of this writ petition.
I'm deeply obliged.
Item number 11.
Please, my lord. I'm appearing for petition, my lord, in this matter. This is for appointment of arbitrator, my lord. I'm so sorry, my lord. I couldn't appear before my lord in person. my
Doesn't
lord.
matter, doesn't matter, doesn't matter. Please raise this, madam.
Yes, she's doing. She's doing. There's some issue in the
Okay.
this thing. She's doing.
Okay. Can I get your name?
Abhinav Prakash, my lord.
A Prakash, okay, yes. For appointment of arbitrator.
Yes, my lord.
Yes, what is the
Pending, sir.
difficulty, madam, for only for appointment?
Yes, Lordship. Only what objection we have put is that he have come after 6 years.
6
Way
years.
beyond limitation.
Is there any limitation?
Yes, 3 years limitation.
Where is it?
Lordship, 8 per section 43 of.
My lord,
And then Lordship, they haven't given any reasonable explanation in their petition also.
Since there is an objection, Mr. Prakash, let us hear madam first, then you can respond to the aspect of
please,
limitation.
my lord. Please, my lord.
Otherwise, appointment is only almost like an administrative direction. There is should not be a dispute
Please, my
or
lord.
objection, but she is raising an objection on the ground of limitation. Let us hear it. Madam, which provision?
Legal issue. She's saying that she has procedure for lunchtime. She will.
No, we can hear her, no problem. We can say there is this.
Here, Lordship, 3 years has not been spelled out, but then in this one, section 11 is 3 years is usually 3 years, Lordship.
No, usually there has to be some, you cannot make a submission out of
Lordship,
thin air. If
in
you are
the-
making an objection on limitation, limitation has to be prescribed. Yes, madam, we need the limitation, the Arbitration and Conciliation Act.
I have not got, but Lordship, in BSNL, Bharat Sansar Nigam Limited versus Lordship, Notel. I forgot the name also. 3 years is mentioned, Lordship, in that case.
Please place on record.
Lordship, facts was also there is a memorandum of understanding between the petitioner and the Suda government, Lordship. They were supposed to make a housing, Lordship, of affordable mass housing, Lordship. But then they have built only 28 flats and they have left.
See, madam, we are not on the merits of the dispute. He may
Yes.
have a case, he may not have a case.
Yes.
We are only on the aspect of adjudication mechanism or resolution dispute resolution mechanism by way of an arbitration. Okay?
Yes, Lordship.
You show us from the Arbitration Act or the agreement that it has to be raised within a particular time. What is the delay here?
Delay is 6 years, Lordship. They have come after 6 years. That's what we have said in the affidavit, Lordship.
So where is there has to be some bar in law that you have to come within a particular period.
3 years.
Where? Please show us.
Lordship. I'm sorry. Lordship, Limitation Act 1963, Lordship. It's a limitation period, generally
63 limitation.
63, Lordship. Generally, Lordship, 3-year limitation period, Article 8 per Article 137 of Limitation Act, Lordship, applies from when the cause of action arises. such as when one party fails to appoint an arbitrator or fails to respond. to
Where,
an-
where is it? Where are you reading?
Lordship, I'm sorry. I'm reading it from online, Lordship.
No, is it a case law?
Lordship, it is in the act itself, Lordship. Mhm.
Please read which part?
Clause Article 137, Lordship. Of the Limitation Act.
Yes. Now, the application of this Limitation Act 1963 per se in an aspect in the matter of appointment of arbitrator, what is the law on that? Arbitrator is not a court. Mr. Prakash, can you throw some light on this?
Please, my lord. My lord,
Yes.
as my learned friend just mentioned that, so far as the Article 137 of Limitation Act is concerned, my lord. So,
Yes.
I mean, my lord, that is very specific, my lord, that is from the cause of action when the cause of action has been arose, my lord. So, from the cause of action, from their affidavit, my lord can reckon if their affidavit they have filed that R1, my lord, at page 5, they themselves said that on oath that the SUDA has issued an order dated 16th November 2017 directing the builder to refund a sum of rupees 3 crore 61 lakh. So this is from their side also. This is the time from where we can reckon the limitation, my lord. Now, my lord, if since there is a limitation of 3 years, so my lord, when up to 2020 that the limitation ends, my lord, 15th November, my lord. In the meantime, my lord, the COVID came, and during the COVID, my lord, there is a specific order of the Honorable Supreme Court, my lord, in suo motu writ petition number 3.
What was the order? What is the date of the communication? 16/11?
16/11/2017, my lord. At page 5, my lord, this is their affidavit, my lord. In their affidavit, my lord. So,
Yes.
yes, my lord. So, from their side also, the from where the limitation can be reckoned, my lord, is 16th November, my lord, 2017. And my
Yes.
lord, besides, my lord, and the 3-year limitation that ends in 2020, 15th November, my lord.
Yes.
Then after, my lord, in the meantime, my lord, the COVID came, my lord. And there is a specific order of Supreme Court, Honorable Supreme Court, my lord, in suo motu writ petition number 3 of 2020, my lord,
Yes.
wherein, my lord, that limitation has gone up to February 2020 plus whatever the time was left in the limitation period. Say in our case, my lord, from February to November is a 9 months. So up to November 2022, there is a limitation. I had the limitation to file this particular petition for appointment of arbitrator, my lord. So this is why, my lord, my humble submission is that this petition is within the limitation, my lord. So, and second part, my lord, I would like to mention, my lord, with some humility, my lord, that limitation is a mixed question of law and fact, my lord. So in this situation, my lord, I'm an arbitrator. They have every right to raise the similar objection, my lord, before they appoint before the arbitrator, which my lord will appoint, my lord. So of course they have every right to do that. So this is the time, my lord, that the arbitrator had to. So, my lord, I have clearly explained before, my lord, that how this petition is within the limitation.
Mr. Prakash, we are on a different question. The application of the Limitation Act qua an arbitration proceeding.
Please, my lord.
What is the settled position of law on this?
On settled position is like, my lord,
Limitation Act will not apply in each and every proceeding.
yes, my lord. But in this limitation act, my lord, so far as arbitration is concerned, my lord, so that part 137 applies, my lord. And that is
What can you throw some have some literature and some Supreme Court judgment?
my lord, if my lord can fix it for tomorrow, my lord, then I can come out with some judgment, my lord, because right now, though, I don't have that literature, my lord. So
because that is the first point we have to decide, the applicability of the Limitation Act.
Yes,
so far as
so, my lord, but
and then
whatever, my
only
lord,
you are required to advance the arguments which you have just made, that there is no it is within the prescribed period of limitation. COVID intervention is there. Supreme Court case is there. So you are within the period of limitation.
Yes,
but we are on a different question altogether. Whether limitation can be taken up as a defense in an application seeking appointment of an arbitrator.
No, my lord.
So that you have to make a submission.
Yes,
on
my lord.
that.
Tomorrow, my lord, if my lord fixes tomorrow, then of course, my lord, I'll just send.
Tomorrow I am not here, but Lordship, I have some difficulties.
Whenever you are there, but this is a very important issue.
Yes, Lordship.
On the
Even
aspect
I
of
if my lord
application of
is okay,
Limitation
then
Act 963 qua the application for appointment of arbitrator.
Lordship.
This we are only appointing. Then the second question will rise, even after appointment, a party can still take up the aspect of limitation if it is so available. Now it is only the question of referring for the dispute to arbitrator. Only the appointment, not only referring. Appointment.
Lordship.
Tomorrow,
Please,
when?
Lordship,
Madam,
anytime,
day after tomorrow, Wednesday, there's a DB, I think. No.
No.
Okay, Wednesday.
My lord.
Mr. Prakash, Wednesday, okay.
Please, my lord.
Heard Sri A. Prakash, Learned Counsel for the petitioner appearing online. Also heard Ms. G. Ate, Learned State Counsel, as well as Mr. Tarak for
Respondent number 2.
with the Public Works Department.
The private party.
Private party. For G. Tarak for the respondent number 2. Tarak. On the request made by the Learned Counsel for the parties, matter is adjourned to be listed on Wednesday. Please give the date.
My lord, they can mention this
11.
particular question, my lord, because ultimately it will be definitely, I think, day after tomorrow.
No,
my
you
lord,
have
yes.
We have sought the time to take instructions on this. Please apprise this court. Okay.
My lord. Hello, blood.
Item number 12.
Mr. Picha, what is this?
Yes, Lord. Lord, this is regarding non-application of multiplication factor in the compensation.
Non-application of?
Multiplication factor. Lord.
Okay, who is for the central government, Mr. Kato?
Yes, Lord.
Your matter, I think your name is reflected.
Yes. Only on the verbal instruction of the Secretary Land Management, my lord, multiplication factor has been, my lord, deleted, my lord.
Basically, factors and assessment also be done by the district administration, acquisition authority by the state.
These are all statutory requirement.
Yes,
How
ma'am.
can you ignore this or say that will not give? Mandate of the statute, Mr. Nawam.
My lord, giving my lord that multiple factors, my lord, if your lordship say state where my lord, page 89, my lord.
59.
Yes, my lord.
Okay, we'll come back.
After my lord, yes.
We have a DB first. After completion of the DB, we'll take.
DB, there is one method, my lord, the transparent posting method instruction, my lord. After that, perhaps.
Single bench, okay.
Yes, yes.
Pass over matter, item number 9.
I'd like to start with the that Uma Devi case also. I have given the list 2006.
The Umadevi has been discussed in details in Upen. When you try to confine your arguments with Upen Das, why you should not follow Upen Das?
Yes, Upen Das, to my understanding, Lordship, kindly see, therefore, before coming to Upen Das, just I wanted to take Lordship to the Umadevi case.
Okay.
Because it's pertinent. State way to the paragraph 55.
Paragraph?
55 laws.
55.
Because giving minimum wages equivalent to the minimum pay scale arising out of this very paragraph laws here. Just I'd like to read. In cases relating to service in the commercial taxes department, the High Court has directed that those engaged on daily wages be paid wages equal to the salary and allowances that are being paid to the regular employees of their cadre in government service, with effect from the dates from which they were respectively appointed. The objection taken was to the direction for payment from the dates of engagement. We find that High Court had clearly gone wrong in directing that these employees be paid salary equal to the salary and allowances that are being paid to the regular employees of their cadre in government services, with effect from the dates from which they were respectively engaged or appointed. It was not open to the High Court to impose such an obligations on the state when the very question before the High Court in the case was whether these employees were entitled to have equal pay for equal work, so-called, and were entitled to any other benefit. They had also been engaged in the teeth of direction not to do so. We are, therefore, of the view that at best the division bench of the High Court should have directed the wages equal to the salary that is being paid to the regular employees be paid to the daily wages wage employee with effect from the date of its judgment. Hence, that part of the directions of the division bench is modified, and it is directed that these daily wage earners be paid wages equal to the salary at the lowest grade of the employees of their cadre in the commercial taxes department in the government service from the date of judgment of division bench of the High Court. Since they are only daily wage earners, there should be no questions of other allowances being paid to them. This is the lawsuit, one of the victims laid down in the Umadevi case lawsuit. Now, how some changes has been brought in the Jagdish Singh case. Then kindly come to page 55 of the Jagdish Singh case. Yeah, 2017. Here it says the wages equal to the minimum lawsuit scale. But so for other allowances are concerned, that state way that has been denied lawsuit. In Jagdish Singh case also, so many issues have been discussed. Even the lawsuit, how the comparison has to be done lawsuit. All those aspects also has been at paragraph 42 and 44. In detail, it has been discussed by the Honorable Apex Court.
Paragraph?
Now I'm coming to the paragraph 55 lawsuit.
Again, same paragraph.
Paragraph 55 lawsuit.
Number is same.
Number is same lawsuit. This is the law laid down by the Honorable Apex Court in Jagdish Singh case lawsuit. Paragraph 55 again. Mayor, in view of all our above conclusions, the decisions rendered by the full bench of the High Court in Avtar Singh versus State of Punjab, dated so and so, is liable to be set aside, and the same is hereby set aside. The decisions rendered by the division bench of the High Court in State of Punjab versus Rajinder Singh is also liable to be set aside, and same is also here. We affirm the decisions rendered in State of Punjab versus Rajinder Kumar, with the modification that the employees concerned would be entitled to the minimum of the pay scale of the category to which they belong, but would not be entitled to allowances attached to the post held by them. It says the minimum of the pay scale. It doesn't say minimum pay scale be granted. There is no the minimum of the pay scale is one thing. And
No, even Upendas has not said about pay scale.
now I'm coming to the
Upendas has said minimum of the pay in the pay scale.
pay. Here, so for other benefits is
Same.
now
It's not nothing to do with the scale. So there is no question of any increment or thing. It's the minimum. See, if in a scale there are certain figures which keep on increasing at a regular gap. Earlier there used to be the aspect of efficiency bar also, EB. Now it's been done away with. But after some period of time, there is an increment. So ultimately there is a scale. So here it's on the minimum of the scale.
Minimum of the scale. The first salary
Yes, first.
basic salary
Yes.
not the other allowances.
Not the others.
Now, kindly see the paragraph 66 of this Jagjit Singh case. Sorry, 60. This is the one aspect which has not been considered by the learned single bench in the present case.
60?
Page 6060.
Para 60.
Para 60, sorry. Para 60.
Yes.
Having traversed to the legal parameters with reference to the applications of the principle of equal pay for equal work in relation to temporary employees, daily wages employees, ad hoc appointees, employees appointed on casual basis, contractual appointees, and the like. The sole factor that requires our determination is whether the employees concerned before this court were rendering similar duties and responsible as were being discharged by regular employees holding the same corresponding post. This exercise would require the applications of the parameters of the principle of equal pay for equal work, summarized by us in paragraph 42 above. However, insofar as the instant aspect of the matter is concerned, it is not difficult for us to record the factual positions. We say so because it was clearly acknowledged by the learned council representing the state of Punjab that all the temporary employees in the present bunch of appeals were appointed against posts which were also available in regular cadre establishment. It was accepted accepted during the course of their employment. The temporary employees concerned were being randomly deputed to discharge duties and responsibilities, which at some point in time were assigned to regular employees. Likewise, regular employees holding substantive posts were also posted to discharge the same work, which was assigned to temporary employees from time to time. There is therefore no room for any doubt that the duties and responsibilities discharged by the temporary employees in the present set of appeals were the same as were being discharged by the regular employees. It is not the case of the appellants, that's the state, that the respondent employee did not possess the qualifications prescribed for appointment on regular basis. Furthermore, it is not the case of the state that any of the temporary would not be entitled to pay parity on any of the principles summarized by us in paragraph 42 here and above. There can be no doubt that the principle of equal pay for equal work would be applicable to all the temporary employees concerned, so as to best in them the right to claim wages on a par with the minimum of the pay scale of regularly engaged government employees holding the same post. This exercise is missing in the present case, Lordship. So that which I have submitted this morning, Lordship, that exercise has not been done. To reach to that conclusion, Lordship, they are in parity, Lordship. And now coming to the open dust case, Lordship, paragraph 22. The paragraph 22 of the open dust, Lordship.
Yes.
इसको दे दो.
Yes, we have.
Kindly come to the paragraph 22 of the open dust.
Yes.
It is, however, heartening to learn that the state government has agreed not to terminate the master roll work charge and similarly place employees working since last more than 10 years, not in sanction post, till their normal retirement, except on disciplinary ground or on the ground of criminal offences. The state government has also agreed to enlist such employees in health and accidental and death insurance scheme, which will be prepared in consultation with the state cabinet. We appreciate this positive stand of the state government taken as welfare measures for the betterment and security of the employees in question. We accordingly direct the state government to implement the measures without further delay. Beside this, we, in light of the decisions of the Supreme Court in the state of Punjab and so, also direct the state government to pay minimum of the scale of the scale to the master roll work charge workers, and similarly place employees working since last 10 years. Here, so far, Lordship, the rest benefits is concerned, Lordship. That is not here, Lordship, which the Honorable Supreme Court has denied. If we say the minimum pay scale be given, Lordship, the pay scale consists of so many things, Lordship.
Not minimum pay scale, minimum of the pay scale.
Minimum of the pay scale.
Of the pay scale.
Minimum of the pay
Of the pay
scale,
scale.
Lordship.
So that is the lowest basic.
Yes, Lordship. But what's the difference, Lordship? Here it does not, it silence on the Lordship, the other benefits.
Let us see the impugned judgment.
Judgment is 8-page, Lordship.
47.
Relevant is 8-page, 47, Lordship.
Scale of pay, it says now. Will pay for it.
At least minimum.
It says a minimum pay scale.
Scale of pay.
Scale of.
Minimum of the pay scale is okay without rest benefits.
Okay.
To that extent, Lordship,
You may be correct in that. You may be correct in contending that.
and so for the other benefits also, Lordship. In Opender, this case also, Lordship. This is not completely in consonance with the Honorable Supreme Court.
In Upendas, that was a concession from the state, the insurance part, that part. Which part?
Last direction, Lordship.
Last direction.
Because the Jagdish Singh's case, Lordship.
Yes.
So for the rest allowances are concerned, Lordship.
What, there is no any other allowance in Upendas.
Yes, Lordship, but it's silence on that, Lordship. But
No,
it,
Upendas is not said you pay. Upendas has only said that pay them the minimum of pay scale
pay scale.
in terms of Jagdish Singh.
Lordship. What I'm pointing out, Lordship, it may confuse the authority, Lordship.
Yes.
Because
this part you may be
this
correct.
is
You may be-
silence on the, Lordship, the benefits, rest benefits, allowances, Lordship. What
No,
is
see, unless there is a direction of this court, it cannot take the form of mandamus.
Lordship?
Neither can somebody claim that there are further hidden directions. You cannot. Direction has to be very explicit. Now, here, so far as use of words is concerned, here the use is at least minimum scale of pay. You may be correct in contending. This is not in conformity with either Upendas or Jagdish Singh even.
Lordship.
But so far as other are concerned, others, if it is not within the minimum of scale, minimum of and minimum scale pay, matter becomes clear.
Lordship. But sometimes it confuses the authority. It may, Lordship, includes the rest benefits also
If
allowances.
you are the authority, how are you confused? You have to take a call.
But if,
They have not made a claim.
if that clarity is given in the order itself, Lordship, in consonance with the judgment, order judgment passed by the Honorable Apex Court, Lordship.
See, we can clarify, as a DB, we can clarify, because this ultimate, this paragraph, ending paragraph, paragraph 30, has given the direction based on Jagdeep Singh and Uma Devi. While narrating the directions, putting it down, the expression has been used as at least minimum scale of pay. It should be minimum of the scale of pay. We'll clarify that.
Lordship, and
We cannot say something more than or less than Upendas or Jagdeep Singh.
Even here also, para 23, clarify,
Yes.
not entitled for any
Not under
benefits.
regulation. Regulation, prayer has been rejected by the single judge. It has not been put to challenge.
Lordship, as Lordship
Because
has pointed out,
in the case of Upendas,
now
regularization was allowed by the single bench. That was the subject matter of challenge by the state.
correct, Lordship.
Here, you are not with that challenge. Regularization has been declined.
Decline.
Interference with the appointments of the private respondents declined.
Decline.
Only on this part.
Only on this part.
That's all I think.
Hello, sir, that's all. And my paragraph 60 also may be considered the Jagdish Singh paragraph 60, Lordship.
60.
60.
60,
Because single bench, Lordship, that not consider all those aspects to reach to at a conclusion that they are in parity, Lordship.
Let us see your reply to paragraphs 11 and 13. In your affidavit?
My affidavit, Lordship?
Yes.
No, Lordship.
Paragraph 11 and 13. How have you replied?
Lordship, kindly come to page 133, Lordship. 133.
33. Yes, your affidavit starts there. We need two paragraphs. Paragraphs 11 and 13.
In 11 and 13, I relied on the stand taken in paragraph
7, 8,
7
and 9.
and 8. So in 7 and 8, we have
7, 8, and 9.
denied those.
You have not denied.
We have
Only for all which is given. There is no denial. There is no denial.
Yeah.
7, if you read 7, that with regard to the main paragraph 6, answering response says, begs to state that the engagement of casual service were made only for the work which is casual and which is not in full time. That we know. But they're in continuous service for the last 18 to 20 years.
But here also paragraph I stated in response to paragraph 11. I said the paragraph amendment made in 7, 8, and 9.
9.
In 9 category, I said, no, see, the nature of duty is to help the regular staff, not engage or employ instead of regular. They have not done any file as done by the regular staff. Hence, it is supposed to claim that they perform the same duty and same work of regular LDC. And in paragraph 8 also, Lordship, I categorically stated there, Lordship, the post of computer operator is not available in this particular government. These all are, if considered and decided, is okay, Lordship, but that has not been.
Good. Madam,
Lordship.
would you like to say anything?
Lordship, regarding
And one more thing.
Yes.
So for as this morning I pointed out, Lordship, there's a policy of the state government. So far that this is concerned, Lordship. This policy seems to be started from year 2019, Lordship, and it was reviewed on 29/5/2023 and lastly reviewed on 19 March 2025, Lordship. The second one. This is the pay scale of the level 4 lawsuit, to which the LDC belongs to. As per this lawsuit, their basic pay is 25,500. 25,500 is the minimum basic pay of the LDC. And if lawsuit see the current policy reviewed on 19 March 2025, this is the employees who serve 20 to 25, they are getting 25,000, and those who have above 25 years lawsuit, they are getting 31,000 per month lawsuit. But this sort of just for information, this sort of classification has been turned down in the Jagdish Singh case. Such classification cannot be given because they are daily worker, labor worker. So that classification cannot be given in Jagdish Singh case in connection to another case. But so far our policy is concerned, it's still in application. That's all.
For more than 25 years is 31,000 or 30,000?
31,000. Above 25 years.
Okay.
Yes.
Yeah, Your Lordship. Lordship has seen that the writ petitioners, respondent writ petitioners had made a categorical statement in the writ petition, Your Lordship. Lordship may see for a moment para 7, Your Lordship, of my writ petition, that is at page number 59 for a moment, Your Lordship.
Here for respondent number?
For respondent number 1 to 7 for all the respondents, writ petitioners, respondents.
You want us to see which one?
Lordship, para number 7, Your Lordship, of my writ petition, that is at page number 59. My writ petition, page number 59. It's annexed in appeal as an annexure, Lordship. It is at page number 59, para 7.
Yes.
Yes, Your Lordship. May I? That the petitioners beg to state that they are qualified for the post of LDC computer operator and is serving as LDC computer operator for last so many years. Be it stated here that the petitioner have rendered their prime age in the service of PHE and WS department. Now their life has been fixed in the department being overage for any other services. They have legitimate expectations for regularizations for their services, but they have been denied of their rights for considerations in the process of regularizations by appointing juniors randomly and without due process of appointment and regularizations. There had not been any public advertisement for the participations in the regularizations of their service. Thus, they have been denied for fundamental rights of employment regularization as entitled under Article 16. The Constitution of India, although they have all requisite qualifications and experience in service. Next, one more para 8, Your Lordship. That the petitioner begs to state that although they are working as regular working as a regular LDC typist, they are not getting the pay equal to the ad hoc regular LDC, but a contingency LDC computer operator. It is pertinent to mention that although they are performing same and equal duty as that of the regular employee, to the extent of doing the duty of regular employee in their absence or in presence of regular employees, such as putting a file, prepare pay bill, issue, and dispatch, and any other computer typing works regularly, but they are not paid salary equivalent to their work. To say their salary is ranging from 15,000 to 17,000, whereas the so-called ad hoc employees are getting salary of rupees 33,000. And also, they are getting other service benefits like earned leave, more casual leaves, and increments. It is stated here that the petitioners have been deprived of equal pay for equal work. They are paid pay lesser than the work performed by them. The action of the authority is violative of Article 14 of the Constitution of India in denial of principle of natural justice and administrative fair play. So these, they have replied, respondent number 4, they have replied, as your lordship has seen, your lordship. They have not denied regarding qualifications. They have not specifically denied. And in after filing of the affidavit in oppositions by ARPOR, we have again filed an affidavit in reply, wherein we have shown duty of rosters, wherein the petitioners were, your lordship, that affidavit in reply they have not annexed in the memo of appeal. It is not disputed that we have not been discharging our duties for the last so many years, your lordship. And the onus of proof, your lordship, we have already...
Which paragraph of your rejoinder affidavit do you want to rely upon?
That is at para 4, your lordship.
Records, we have the records, huh?
Para 4. We have shown the charter of duties, your lordship.
Paragraph?
Paragraph number 4, page number 3, page 3. And annexure is at page number 7.
Record
Record is not there, it's not available.
No, along with the writ appeal, the petition would come. The petition which has been disposed.
Copy, I don't have, your lordship, but I have the copy, your lordship.
How many pages?
Only one, annexure is only one page, and
Not annexure.
my affidavit in reply is only, your lordship, starting from 1 to 6, only
6 pages.
Six
Along with
pages.
enclosures are also there.
Yes, your
How
lordship.
many enclosures?
Along with the enclosure, it's total page 68, your lordship.
What enclosures are those?
Your lordship, these are the appointment of those, some juniors who were appointed during the pendency of
Those
the
would not be
petitions.
required.
I'm relying only the
You read the environment which you are relying, page
Yes, your
paragraph 4, I think.
para 4, your lordship. That with regard to the statement made in paragraph number 7 of the affidavit in oppositions, your humble deponent denies the statement that the casual and the contingency are entrusted to do minimum amount of work with lesser responsibilities. This is in theory, but in practice, the petitioners are casual, but the petitioners who are casual are working more than the regular staffs. The order dated 17/11/2020, issued by the Assistant Engineer, PHE, Mechanical Electrical Subdivision, Itanagar, goes to show that the petitioner number 1, it is in respect of petitioner number 1, Dubi Bagra was ordered to perform regular duty. The contention of the respondent is bereft of facts. That annexure I have annexed, your lordship. During the COVID time, 2 of the writ petitioners were engaged as a regular, to render the regular duty. Likewise, your lordship. So, your lordship, the learned single judge, after examining the documents, after examining the proof, and then the categorical statement which I have stated in the petition, your lordship, has rightly...
What is your take on the last part? See, there are 3 issues.
Lordship.
2 issues have been decided against you.
Against me.
You are not aggrieved by those.
No, your lordship.
Yeah, and the state is aggrieved by the 3rd issue. wherein there is a requirement to pay the minimum pay scale, not in minimum of pay scales, which there appears to be a difference of the expression, both in Jagjit Singh, Upendas,
Lordship.
where the emphasis was to give certain minimum standards, which is, what is it? The minimum of the pay scale, not the pay scale as such.
Minimum of the
In
pay
this-
scale.
In this judgment, in spite of mentioning Jagjit Singh and Uma Devi, Upendas was perhaps not brought to the notice, but the expression is this minimum pay scale. What is your take on that?
Lordship, since the two of the prayers, Your Lordship, were not decided in favor of me, Your Lordship. So I have a legitimate expectation, Your Lordship, at least minimum pay scale, Your Lordship.
No, but that is not, doesn't seem to be in consonance
present
with Jagjit Singh, Uma Devi and Upendas.
Lordship.
Maybe
Lordship,
it's-
that
maybe
can
it's a
be,
use of certain expressions, but it will have different meaning. Minimum pay scale and minimum of the pay scale.
minimum of the pay
And
scale. That can be, Your
Mr.
Lordship.
Kapil has been emphasizing with additional documents that as per the present policy, one who has worked for more than 25 years would get 31,000 fixed. But if you go by the minimum pay scale, minimum of pay scale, that is up maximum of, you'll get the cap is of 25,500.
Lordship. That Lordship, I leave up to Your Lordships. That can be, Your Lordships can.
Let us see if we can also
May-
mold it.
Yes, Your Lordship.
Should not be, by a judgment of the court, you should not be prejudiced if it's in your favor.
Yes, Your Lordships. Only my prayer is that the appeal may not be allowed and learned single judge order may be not interfere in terms of rejecting pay scale, Your Lordship. I'm entitled, at least I'm entitled for minimum, Your Lordship.
I will reserve this, for Sri Estapin, learned senior advocate for the appellants, also heard Ms. Ananju, learned counsel for the respondent petitioners. The hearing is concluded, judgment is reserved.
Obliged.
We try to have it delivered this week itself when both of us are here. Okay. You can live, huh? I'll give it to you. You can rise? Well, single bench within 5-10 minutes.
Also one matter number 9.
Your Lordship.
Instructions, madam?
Yes, I received the instruction from the department, Your Lordship, over the telephonic. They said that the petitioner has not been released, Your Lordship, and the reliever has joined the post, Your Lordship.
If he is not released, how is he joined?
The reliever, Your Lordship, as I received the instruction, Your Lordship.
Good to order. Where's my note? Where's my note? Huh? No, small note like this, I had written something. No, it's not been said. Put a note. No? That's not mine, no, that's not mine. Okay, doesn't matter. Okay, then what do you propose, madam?
Then next date, Your Lordship, I will get the proper instruction, Your Lordship.
So you maintain status quo. Okay. I don't know. I don't know. Later. Figure it out.
We'll take somebody.
Good. Use that chapter. This is item number
9, Lordship.
third, Sri D. Boje, learned counsel for the petitioner who has put to challenge an order dated 1/2/2026 by which the petitioner has been transferred to the lottery, what do you call section?
From lottery to lottery branch to.
Lottery branch, to
To,
the science and technology
Sci-
branch.
yes.
Full stop. It is the case of the petitioner that he has served for the last about 25 years.
Yes, more than 25 years.
Last more than 25 years. And wide an order dated 3/2/2025, he was transferred to the education department. Full stop. Immediately thereafter, within a span of less than 3 days, wide an order dated 6/2/2025, he was again transferred to the lottery branch. Full stop. The petitioner claims to have joined the state branch on 7/2/2025 and was discharged and has been discharging his duties. Full stop.
Lordship.
However, the present impugned order has been passed on 1/2/2026, again seeking to transfer him. Full stop. The petitioner has submitted that apart from the aspect of frequent transfer, comma, there is malafide in the impugned action, which has been orchestrated by the respondent 3. Full stop. Para. Let notice be issued, returnable on, we give a short date. You serve Dusty.
Lordship, may I pray that maybe notice may be returnable within 2 weeks.
I
Lordship.
will make a short date. We have to serve Dusty, okay? Today is 9. Returnable on 25/2/2026. Miss
Yes.
Pango, the learned government council, accepts notice on behalf of respondents 1 and 2, extra copies for 3 speed post to TD, steps within 2 working days. Additionally, the petitioner is directed to serve the respondent 3 by Dusty, which is to be routed through the registry of this court. Full stop. Prior to the next date. No, before that you write. In the notice accompanying the Dusty, the next date is to be specifically reflected, and prior to the next date, the petitioner is required to file an affidavit as proof of such Dusty service. Para. 3. Boje, the learned counsel, prays for an interim order by submitting that the petitioner is yet to be released. Full stop. Para. Time was granted to the learned state council to obtain instructions when this matter was taken up in the first half. Full stop. The learned state council has submitted that telephonic instructions have been received as per which though the petitioner has not been released, comma, the reliever has joined.
Yes, Your Lordship.
Has joined. Considering the above, comma, it is directed that status quo as in today be maintained till the next returnable date. Para. Since this order has been passed ex parte qua the respondent 3 and at the motion stage, comma, the same would be reconsidered on the returnable date.
Obliged.
Highly obliged, Lordship.
Item number 12.
Where is item number 12?
Yeah, but This is, my lord, regarding land compensation, my lord. Non-application of, my lord.
Item 12.
Yes, my lord.
Yes, Mr. Katur. What is your grievance?
Basically, we have no grievance, my lord.
No. Not your grievance, his grievance.
Mine.
Why should you have a grievance?
Yes, sir.
You are the Bharat Sarkar.
Bharat Sarkar, ultimately money is to.
Cannot have any grievance.
My lord, what happened? The user agency, my lord, had made a requisition, my lord, for acquisition of.
Why is it listed today? For admission?
Yeah, for admission, no?
Yes.
Admission, pleadings are over.
My lord, the state has filed their affidavit, my lord, with no comments.
Very good for you.
Yes, good for me, my lord.
And Central?
Central, my lord, we have not received, my lord.
We received the parawise comments.
Comment. My lord.
Instructions not received.
My lord.
So what do you do?
My lord, one more time, chance may be given, my lord.
Here, the issue of law is there. my lord.
Issue of?
Law.
Oh, you said?
Yes.
Said
Multiplication factor, my lord.
There
Huh?
are multiple factors. my lord.
multiple factors.
Yes,
Yes.
madam. I was supposed to address your lordship,
Yes,
but
sir.
my brother started.
Hmm.
Honorable, ne?
My lord, this is land from.
Can we do without the instructions by Mr. Kato?
Yes, my lord. And the documents is here, my lord.
Basically, it is on multiple factors, my lord. If it is then, my lord, it is okay, my lord. Otherwise, my lord, district administration has to decide, my lord, basing on the, my lord, statute relevant law 2013, like, my lord.
My lord, what? There is a state notification, my lord, for applying multiplication factor, page 63, my lord.
63.
Yes, my lord.
63, no? 63.
Now, in consonance with this notification of 5 July 2016, my lord, the multiplication factor was applied in my case, my lord, page 64, my lord. 1.2 was applied, my lord, in my case. Page 64, my lord.
1.2.
Director?
Page 64, there's a board proceeding, my lord, board proceeding report. Here, the multiplication factor 1.2 was applied in my case, my lord.
Who are you?
I'm the beneficiary, my lord.
No,
Landowner.
name. Serial number?
One. Sangasir to Sulula.
Sulula.
Yes, my lord.
Serial 1.
Yes, serial number 1. Now, my lord, the board has also prepared the estimate, my lord. Page 65, my lord. In the table
Page
7.
65.
Page 65, yes, my lord. This is the estimation amount, my lord. In the serial number 7, my lord, or 8, my lord, table 8, my lord, 1.2 was applied, my lord.
Column 8.
Yes, my lord.
Column number 8.
Yes, my lord. 1.2, multiplication factor 1.2, my lord. Now, the total compensation was, my lord, 13 crore, my lord. Only in respect to beneficiaries, my lord.
Yes?
Only in respect to beneficiaries, my lord. It was, total compensation was estimated to 13 crore 21 lakh 79,000.
Yes.
In grand total with the administrative, my lord, expenditure 14 crore expenses. Now, my lord, what happened? Everything was going
This is the estimate prepared by the committee.
Yes, my lord. Then, my lord, there was a minute of meeting, my lord. Page 69. We were made known that we are only entitled for 11 crore 11 lakhs 98,000, my lord. Down below, my lord, it was also decided next week by the district administration, my lord. They have cheated us, my lord. They have committed fraud upon us, my lord. Now, actually, our entitlement is, my lord, much bigger, my lord. So, my lord, the award, page 71 is the award, my lord. My lord, these people are all villagers, my lord.
What is page number?
71. page 79 is our RTA.
79
is our RTA. My lord. The petitioners, all the villages are, my lord, petitioners are villagers, my lord. They don't know technicalities of law, my lord. Now, one of the, this Lama petitioner number 1 has filed an RTA, my lord. Page 79, my lord. From RTA, we came to know about award, my lord, which is also admitted in their affidavit by the state, my lord. Even the award was furnished to us by RTA, my lord. My lord, page 80. Copy of final award with respect to Sangesha Sulu BRT, 3 pages, page 80, my lord. On 12 September, my lord, they have furnished us. So we submitted our representation, my lord, for payment of compensation as per actual estimate, my lord. Page number 81, my lord. Our representation, my lord. Now, in response to our representation, my lord, very interestingly, my lord, the district administration, my lord, has furnished us a reply, my lord. The estimate multiplication factor was reduced, my lord, by the verbal order of the Secretary Land Management.
Page?
Page 89, my lord. Para number 5, my lord. The revised estimate for an amount of
What is it, 89?
is the communication letter, my lord, in response to our representation, my lord. We have submitted representation on 29/9/2023, page 81. In response to this, our representation, with reference, my lord, the subject here it is mentioned, my lord. With reference to the subject cited above, para was replied to the petition dated 29/9/2023, my lord. This is our representation, my lord.
Yes.
Para 5, my lord, para number 5. A revised estimate for an amount of rupees so and so, only with multiplication factor 1 was prepared in compliance with verbal order of the Secretary Land Management. Only on the verbal instruction. My lord. Now, my lord, what happened, what they have relied, my lord, is page 90, my lord. This one is also interesting, my lord. My lord, here, there are more things, my lord. May I read, my lord? In verbal order of Government of AP and subsequently government notification number 6/9/2022, my lord. This may be considered, my lord. 6/9/2022, my lord. Previous LA estimate was prepared, my lord.
Where are you reading? Page?
Same. Page 89, my lord. Same,
Yes,
column.
yes.
Para 5, my lord.
Yes, yes.
So the government notification, my lord, 6 September 2022, my lord. This date may be considered, my lord. Now, my lord, page 90, my lord. This is the communication by the DC to the Secretary Director Land Management. My lord. This was furnished with the, my lord, our
RTA.
communication. Yes, my lord, communication, my lord. To our, in response to our representation. My lord. This is the annexes together, my lord. Now may I read, my lord? Page 90, my lord.
Yes.
This is of, my lord, this date are very crucial here, my lord. 21st March, my lord, 2022, my lord. Pursuant to the direction issued in the meeting held on 28/2000 in the office of the Chamber of Secretary Land Management, Itanagar, the reverse estimate cost of land being acquired for construction of Sangesar Sulala BRT Road in Jimithang Circle has been prepared after considering the multiplication factor as 1, and a copy of the same is hereby forwarded for necessary action. Now, page 91 is the estimate, my lord. Now, this was prepared on 21st March, my lord. 21st March is the communication. Now, they are relying on the one notification of 6/9/22, which did not come into existence, my lord. Though the communication is of 21st March, my lord. And they are relying on the notification that is 6/9/22, my lord.
Where do you get?
Page 89, my lord. Para 5, my lord.
Yes.
A revised estimate of for an amount of so and so, only with multiplication factor 1 has been prepared in compliance the verbal order of Secretary Land Management and subsequently government notification number so dated September 6, 2022. So, but the communication, page 90, my lord. Communication is of 21st March, my lord. In that time, my lord, this September has not come into existence, my lord. 6/9/22, my lord. The notification which did not come into existence, my lord, they have relied on that notification, my lord. The communication is of this is the estimate, my lord, prepared by the DC, my lord, is of 21st March 2022, my lord, page 90, my lord. Page 91 is the second, my lord, estimate, my lord, prepared by the DC, my lord.
But the DC's communication though of 21st of March 2022
Yes,
has also taken the multiplication factor as one.
Yes. Yes, ma'am.
So how does it?
Now, there is a state notification, ma'am, that, and there's a board decision also, ma'am. 1.2 should have been the multiplication factor. In this context, ma'am, I have some
Board
judgment.
proceeding, what is the date of the board proceeding? Page 64?
Page 64, my lord. 64, my lord, it does not contain a date, my lord.
Board proceeding?
Yes.
No, that nothing.
But what I say, my lord, award is both, my lord, bad in law, my lord. It is not as per the requirement of the act, my lord. When act requires something to be done in a particular manner, my lord, it has to be done in that manner. May I rely on judgment? my lord?
No, judgment is Nazir Ahmed is okay. You are relying on Nazir Ahmed.
It is 2012, 6 years. ma'am.
The original case is 1936 Privy Council.
This is also in relation to compensation, madam. It. Usaben, my lord. Usaben Kishori Lal, Kishori Bai, Sunilal Talpara.
No, but that point of law is okay.
Yes, my lord.
What is prescribed by law, that has to be done in that manner only, by no other manner.
Yes.
But what is the prescription of law here in your case?
Multiplication factor has to 1.2, my lord.
From where do you get?
26, section 26. my
Of?
lord. Lara Act, my lord.
No, that depends area wise. Last urban, rural, technical distance.
Section 26, subsection 2, my lord. Which is in consonance with schedule 1, my lord. First schedule. Ma'am, section 26, my lord, subsection 2. Market value calculated as per subsection 1 shall be multiplied by a factor to be specified in the first schedule, my lord. Now, first schedule, my lord. May I read, my lord? First schedule. So number 2, factors by which market value is to be multiplied in case of rural areas. 1 to 2, based on the distance of project from the urban area, as may be notified by the appropriate government, my lord. Now, the state government has applied has issued a notification, my lord, already. Now, that was not.
Where is the first schedule?
First schedule in my act, my lord, page 51. my lord.
First schedule, which one? Yes.
First schedule, yes, my serial number 2, my lord.
Schedule 2. One to two.
Yes, 1 to 2. It should be based on 1 to 2, my lord. Basing on the distance, my lord, of the project. I have some judgment of high courts, my lord. Other high courts, my lord.
Now, the multiplicand should be 2.
1 to 2, my lord. It should
No,
be.
read the star, asterisk, and the notification.
2, yes, my lord.
The notification.
Notification, yes, my lord.
No, asterisk. There is an asterisk.
Okay, my lord.
Asterisk after notified, as may be
Yes.
notified.
by the appropriate government. The
Read
government has
down-
notified. In our case, government
Read
has.
down below, read down below.
Yes, ma'am. Okay. This is the central Malut. Nekpun Malut.
Yes.
Central notification. State has some notification. State has a notification at page 63 Malut. Of 5 July 2016. Malut.
Page
63. of the-
63.
May I read?
This we have already seen.
Yes.
Uh,
This is the multiplication factor. Malut. Notification for multiplication.
This has been done as per section, first schedule,
Yes, ma'am.
first schedule.
This notification has also one background, Malut. One litigation was there, Malut. Tipak Taing versus State of AB, Malut. By the
But is the radial distance from urban area 11 to 20 kilometers, is there any dispute with this
no,
regarding your area?
no.
No dispute. So why have you reduced? Mr.
My lord, that is the ground, my lord.
See, there is a
No.
statute, the 2013 statute, along with a schedule. Schedule says 122, and for that, appropriate notification. Notification is at 5/7/2016, not in dispute. It says for 11 to 20 kilometers, it
My
should be
lord,
1.2.
Sorry for interruption, my lord.
Yes.
Now, my lord, the 5th July 2016, my lord. Now, everything has been, my lord, defined here. 0 to 10 kilometers, the multiple factor will be, my lord, 1.5.
One.
I'm sorry, 1, my lord. Then 11 to 20, multiplication of 1.2, my lord. Now, the petitioner is saying, my lord, that this multiplication 1.2 should have been applied, my lord. That was done by the board meeting, my lord. But when you see the communication from the secretary to the deputy commissioner, my lord, they are referring some notification, my lord, 2022, my lord, which my brother is saying, my lord, that will not be made applicable. Then if that be not be made applicable, then we have to see the notification. When, my lord, this notification for land acquisition was issued, my lord, that was issued only 2022, my lord. Now, how do you determine, my lord, whether, my lord, the distance from the urban is within the 10 kilometer or beyond the 10 kilometer? That is not clarified, my lord. Neither they have shown anything, my lord. Even the board meeting says, does not say anything, my lord. That is falls under, my lord, these kilometers, my lord. Now, the board committee, my lord, they have, my lord, applied these factors, my lord, 1.2, no doubt about that. Then perhaps, my lord, when this deputy commissioner, my lord, got a communication from the secretary saying that there is another notification, because this notification 2016, there is subsequent notification of 2022.
Yes.
My lord, who says that you have to apply ratio of 1, my lord, not 1.2, my lord. And that notification is not under challenge. That was, my lord, accepted by the deputy commissioner. That's why, my lord, there is, my lord, difference of, my lord, total compensation. If your lordship see, my lord, the communication by the letter, my lord, page 89, my lord, annexure 17, my lord. Page 89, my lord.
Just a minute, please.
This is a letter to the, my lord, petitioner, perhaps written by the deputy commissioner, say on behalf of, my lord.
So this estimate, Mr. Pichha, this estimate at page 65 and 66 were made when? When was the land acquired?
My lord, there is a
My lord, 67, my lord. This is the notification, my lord.
31/8/2022.
Correct.
67.
No, not
67.
67. The estimates which you are relying upon at page 65. This was prepared when?
It does not contain date.
No date, nothing, my lord.
But it refers to that the multiplying factor
Yes.
Is
under the
1.
first schedule has been taken by as per government notification 5/7/2016, the last line
Yes, ma'am.
at page 65,
Yes.
right?
Yes.
Right, my lord.
So, but there is no date here. And there is a notification at page 67.
My lord, here, my your lordship may kindly mark, my lord. Your lordship has kindly noted, my lord. This last thing, my lord, the certificate. There are two clauses, my lord. Page, my lord, 65. Just now, your lordship report, my lord.
Yes.
Yes, the multiplying factor under the first schedule of the act has been taken as per government notification dated 2016, my lord.
5/7/16.
Yes, there is subsequent notification, my lord, 2022, my lord. Yes, exactly. I wanted to page, my lord. There is a communication, my lord. If you lordship come to page 89, my lord.
89.
Yes, my lord. Para 5, my lord. Just now, my brother he read this one, my lord. Has your lordship got it, my lord?
Yes.
Two things, my lord, here. The revised estimate for amount so and so, only with multiplication factor 1 was prepared in compliance the verbal order of the Secretary LM, government order purchase, and subsequent, very important, subsequent government notification number dated 6 September 2022.
Let us see 6 September.
My lord, unfortunately, no one annexed this notification, my lord. So, the previous, my lord, factor was applied because of 2016 notification, my lord. Now, since, my lord, this acquisition comes under, this acquisition was, my lord, done 2022 only, my lord. Obviously, my lord, this notification will apply, my lord.
Acquisition done in 22.
Yes, if you lordship see the notification, my lord.
Notification now 2021, my lord. Page 62. my lord.
Now, what this was, 67 is what?
Position.
Possession. Yes, this is possession. But one thing is very clear, my lord.
Yes.
21, no doubt about it. Notification, then, my lord, assessment, the possession, everything was done, my lord, is 22, my lord.
But
2022.
notification is of 3rd November 21.
Correct, my lord, notification. What I am concerned
Position
with,
was taken on 31st August, my lord, before September, my lord, 2022. my lord. Page 67.
this is the. Mhm. This communication is of 3rd November. September, this is August, September, actually, after that. Then let's see the assessment. Where is the award? Awards, okay. February. Then you'll automatically mark the award date, my lord, award. That is 71, my lord. It's much later to that notification, my lord. This is 14 February 2023, my lord. I believe, my lord, before award is passed, my lord, they can change the multiple factor if something, my lord, subsequent government notification is there. Then. Maybe because of that reason, my lord, they have reviewed that, my lord, estimate, my lord. And this was carried out, my lord, prior to, my lord, final award, my lord. Otherwise, I agree with my brother, my lord. It's all subsequent to my lord that notifications, my lord. Land acquisition, even position, my lord. Now, what we have to see, my lord, when award was passed, my lord. So award was passed, my lord, after the notification, my lord. Because this is award is, my lord, 2023, whereas subsequent government notification 2022, my lord. It's much later, my lord. Maybe because of that, my lord, the revised estimate was carried out, my lord.
But what are you-
Otherwise, I don't
what-
see any other ground. my lord.
What are you required to take into consideration?
Well,
The position of law and facts at the time of initiation of the proceeding.
Yes.
Here in the preliminary notification was of 3/11/2021
21, no doubt about
and possession was taken over on 31 August 2022.
Yes, sir.
my lord. My lord, that is also quite, my lord,
And this
My lord,
verbal instruction also appears to be slightly.
my lord, Barwell instruction, my lord, and subsequent government notification is takes about two things, my lord. The communication made by the deputy commissioner to the petitioner. One is there is Barwell instruction from the secretary. Look, you have to comply with the government notification, my lord.
AG, the entire objective of the Lara Act
My lord.
was not to cause prejudice to the land, the affected persons.
Absolutely.
The entire objective was to give them more benefit.
Yes.
And even cases which were under the earlier act, and if the proceedings are continuing, those they will get benefit under the Lara Act, where the
New one.
benefits are much more.
My lord.
So under those consideration, under the schedule, first schedule, the appropriate authority is entitled to take out a notification.
My lord.
State of Arunachal accordingly had taken out a notification on 5/7/2016
16, correct, my lord.
regarding multiplicand is 1.2
My lord.
for a particular distance.
Correct,
Distance factor is not in dispute.
My lord, it's very difficult on my part to agree, my lord, whether
But
this.
we have not disputed.
But we have not disputed.
They have not disputed. So we have to go by the assumption that 1.2 was correctly done in terms of a notification.
My lord.
Not because of any difference in distance.
My lord.
Now your defense would be that subsequently 22, another notifications come where the multiplicand has been made 1.
My lord.
And only thereafter the award has come. So there may not be considered there is any error in the award by taking into the latest notification.
Well,
that is your contention?
Another, my lord, if they have any grievances, my lord, so for compensation, measure, assignment, my lord, your lordship ever 64 is
64 is there.
Yes, my lord. Now, my lord, just
Welcome.
now.
Which I have a sit.
Yes, my lord. Now, my lord, we have to once again, my lord, see, my lord, what exactly the 16th September 2020 contains, my lord. It also contains, my lord, multiple factor rules says, my lord, no, under this kilometer areas, you have to apply one, my lord, multiple one, my lord. If that be so, then they have to challenge the notification, my lord. My lord, otherwise I don't find any bona fide ground, my lord, for revision of that amount, my lord.
Let us have a look at the award.
Well, a subsequent government notification number so and so dated 6 September 2022. Previously, land management, land acquisition estimate was prepared with multiple factor 1.2. Therefore, the same land assessment was higher than the latest one. Now they are saying, my lord, because of non-application of, my lord, 1.2, there is a lesser amount, my lord. Now we have to see, my lord, what exactly the 6 September says, my lord. If there is a restriction to apply 1.2, then, my lord, they have to challenge it.
Okay, yes, Mr. Kato, anything extra?
I will clarify one.
We will come back to you.
My-
Your friend has, AG has already
Yes, madam.
put on details. Anything you'd like to add?
No, madam,
We'll,
submission made by the
6 September. उसको लेके everything clear है तो My lord, may I switch for me, my lord. My lord, may I excuse me for
Yes,
me,
yes,
my lord.
yes. We'll hear Mr. Picha. In the
Yes,
meantime, we'll continue.
Page 90, my lord. Answer is here, my lord. The revised estimate. My lord, may kindly consider the date, my lord, page 90. 21st March 2022, my lord. Subject.
90, page 90.
Yes, yes, my lord. 90. Every answer is here, my lord. My lord, may see the subject, my lord. Forwarding of revised estimate cost of land, my lord. So this is of communication of 21st March 2022. Before coming in force of notification dated 6/9/22, my lord. After preparation of this revised estimate, my lord, the DC has forwarded it to the Director of Land Management, my lord. So, my lord, this revised estimate was prepared before coming in force of second notification, my lord, 6/9/2022. my lord. This letter is of March, my lord. This is of September, my lord. That notification is of September, my lord. As per the communication at page 89, my lord. So we can say, my lord, the revised estimate was prepared before 21st March also, my lord. Because this is only the communication, my lord. After preparation, my lord. My lord. Then, my lord, on the maintainability part, my lord, I would like to submit some.
Maintainability or that you're not going for a reference?
Yes, my lord. Our High Court has also passed some judgment, my lord, when the authorities fail to discharge their duties, my lord. It would be maintainable, my lord. This is on the ratio of, my lord, writ maintainable when authority fails to discharge its statutory duty, my lord. Paragraph 15, 16, 19. my lord. This is also regarding the compensation, my lord. Here also the award was passed, my lord. After passing of award, my lord, they have filed a writ petition seeking solution, my lord. May I read, my lord? Para 15.
Para 15.
15, 16, and 19, my lord. This would mean, para 15, my lord. This would mean that while determining compensation and making the award, it is the duty of the collector to take into consideration the mandate of subsections 1A and 2 of section 23 of the LA Act 1894. The person interested in statutorily entitled to benefits conferred by the aforesaid two subsections. Correspondingly, it is the duty of the collector to confer such benefit under the aforesaid two provision to the person interested. Failure to do would be a breach of statutory duty based on the collector, my lord. On the top, my lord. Now, my lord, para 16. Question for consideration is whether in the event of such failure on the part of the collector in the discharge of statutory duty as per mandate of section 23(1)(8), section and 23(2) of LA Act 1894, read with section 15 of the said act, what would be the remedy available to the affected person? Interested persons interested. No doubt he can avail the remedy of section 18, which is, my lord, reference court, my lord, as per LA Act, and seek a reference. But having regard to the objective of two provisions coupled with the compulsory nature of land acquisition, to our mind, it would be highly unfair, unjust, and untenable to restrict the aggrieved persons interested only to remedy under Section 18. Such an aggrieved person may approach the collector concerned under Section 13A of the LA Act 1894, where under the collector can correct clerical or arithmetical mistakes in making the award, either on his own motion or on application of any interested person or a local authority. We say this because awarding of interest under Section 21A and awarding of solicitation under Section 23(2) is statutorily mandated. It is automatic. Once market value is determined, interest and solicitation thereon has to be granted. There is no question of any long-drawn argument or debate over the entitlement or on the quantum of the interest and solicitation, because these are statutorily provided. One of the market value of land is determined by the collector. He has to apply the formula provided under the aforesaid two provisions to arrive at the quantum of interest and solicitation. If there is omission on the part of the collector to grant interest and solicitation while making the award, it would be a mistake or an error apparent on the face of the record. Therefore, such an error or mistake which come within the ambit of Section 13A of the LA Act 1894 would be corrected by the collector himself. Now, 19, sorry, para 19. Now, coming to the next question, as to whether such a claim also to be maintained in a writ petition, as already discussed above, claim of interest and solicitation is a statutory right of a person interested. Non-payment of such interest and solicitation would be a failure on the part of the collector to discharge duty vested on him. If there is such failure on the part of the public authority in discharge of statutory duty, certainly a writ would be well within its jurisdiction to issue a writ mandamus to compel the public authority to discharge its statutory duty. The fact that alternative remedy is available under Section 13A and 18 of LA Act 1894 would not debar the writ court from exercising such jurisdiction in an appropriate case. I have made allegation of cheating, my lord, upon the respondent authorities, my lord, and they have not controverted it, my lord. So it should be deemed admitted, my lord. So, my lord, 1995 SC 1004, my lord. Para 11, my lord. Paragraph 11, my lord. Paragraph 11, 21 line, my lord.
Para 11.
Para 11, yes, my lord.
It starts with it is true.
SL, its legality or correctness. Yes, my lord.
It is true.
Yes, it is true. My lord, may come down below in serial number paras 21. SL, its legality or correctness. SL, its legality or correctness, my lord. 21 line. May I read, my lord?
No, we're not getting it. Which paragraph 11, which line?
21, my lord. SL, its legality and correctness, my lord. Or correctness.
After Himalayan tiles. After year 1980.
Yes, my lord. Down below, my lord. 81, 2, 3, 4, 5, 6, 7, 8. 8 line, my lord. After AI 1980 SC.
If not made a party.
SL, its legality, my lord. My lord, after AI.
SL is legal, yes.
Yes.
When the award.
Yes.
Thereafter, when the award made.
Yes. When the award made under Section 11 of the collector is vitiated by fraud, collusion, or corruption, the beneficiary is entitled to challenge it in the writ petition. Apart from settled law, the conduct of the collectors or civil judge is amenable to disciplinary inquiry, appropriate action. These are very valuable and statutory rights.
Salutary.
Yes, salutary rights. So, writ is maintainable. On non-application of my lord, multiplication factor, my lord, may I- This is a Bombay High Court, my lord. By the Division Bench of Bombay High Court, my lord. Para 2 and 12, my lord. May I read, my lord? Para
Just
2.
a minute, just a minute, please.
Para 2 and 12, my lord. This question has come into in this case, my lord.
Para 2.
Para 2, my lord. The question, my lord, here the question was framed, my lord.
Yes.
May I read, my lord? Para 2. All the above writ petitions have been filed raising the same question of, namely, in acquisition proceedings, whether an award can be passed without applying the multiplication factor as specified in first schedule of the right to fair compensation. Now, my lord, para 12, my lord. Page 6, my lord.
Para 12.
Yes, my lord. From my lord, para 12, from the right side, 6th line, my lord.
Yes, the manner.
Yes, my lord. The manner of determination of value is that multiplication factor has to be between 1 to 2, based on the distance of the project from the urban area, as notified by the appropriate government. In other words, whilst determining the compensation in case of the rural areas, appropriate government has to notify the multiplying factor as contemplated under entry 2 of first schedule of 2013 Act. On plain reading of section 26 with section 30 of and the first schedule, it is clear that before any award is passed in relation to any land in rural areas, the aforesaid multiplication factor has to be applied. Passing an award without applying the multiplication factor would be contrary to the provisions of section 26 to 30 of the RTA of the 2013 Act. Here, finally, my lord, the award was first and set aside. Para 24, my lord. Page 11, my lord. But I have one way out, my lord. I have one judgment of Gujarat High Court, my lord, which has a way out, my lord. And we'll get to there. For redetermine compensation and modify the award, my lord. This is, sorry, my lord, this one is not proper. That would be wrong, my lord. There would be another
Not this
judgment.
one, not this one.
Yes. I have challenged the award, my lord. in my writ petition, in the prayer, my lord. Better way, my lord. Paragraph 9, my lord. May I read, my lord? In this case, my lord, the authorities were directed to redetermine the compensation, modify the awards, my lord. So this is the way, my lord, which we can amicably solve.
Paragraph?
Paragraph 9, my lord. May I read, my lord? Considering the submission made by the Land Council for the respective parties, it is indeed surprising that despite issue being concluded in as much as the decision in the case of Dheeraj A. Patel Supra has been confirmed by the Supreme Court, the Council for the National Highway Authorities of India would oppose the granting of such prayers when in series of orders as referred to herein above. This court has followed the decision in case of so-and-so Supra and issued direction to redetermine the compensation and modify awards and pay amounts to such beneficiaries of the awards by applying factor 2 and pay such compensation with all statutory benefits, including solutium under so-and-so.
So how does it benefit you, this part? Paragraph 9?
By quashing the award, my lord, they may be directed, my lord, authorities may be directed to redetermine the compensation as per multiplication factor of the state and pass a fresh award, my lord. No exercise has to be carried out, my lord, because estimation has already been done, my lord. They have to only pass a fresh award, my lord. Para 10 also, my lord, has some significance, my lord.
Yes, paragraph
10, my lord. The exercise of application of factor 2 and recompounding the compensation by applying factor 2 under section 26 subsection 2 of the Act shall not amount to reviewing or modifying the award. What is in fact being undertaken is the award in question, irrespective of the parties concerned, are being modified or revised by the multiplying the market value as determined that under section 26(1) of the Act 2013 with factor 2 as per section 26(2) of the Act in the light of the position of law set out in the case of Dheeraj A. Patel Supra. At this stage, it needs to be noted that in light of the position law decided by this court, in that case, authorities are expected to apply factor 2 in all cases where the lands fall under the rural areas, and awards accordingly need to be modified if the compensation has been paid in such case by multiplying factor, market value, and approach. This may, my lord, this may come into question, my lord. Well, accepting compensation, my lord, does not amount to acquiescence to the acquisition if such proceedings are otherwise wrongful and illegal, my lord. Since I have accepted compensation, my lord.
that they have not been raised this.
My lord. That they may, just in case, my lord. Should I, my lord?
That's all.
Yes.
No, not required. They have not raised even. They have definitely raised 64.
My lord, one thing, my lord,
Could have been 18, now 64 is their reference, is possible. That you have answered already.
my lord. One thing, my lord, I would like to answer, my lord. Oh, these are villagers, my lord. They don't know the technicalities of law, my lord. For that, I want to place one judgment, my lord.
Yes, please.
Yes, ma'am. There is a concept of legal aid, my lord. Door-to-door legal awareness, my lord. These people, villagers, they don't know the law, my lord.
मतलब simple terminology, मतलब
Ignorance of law. is-
Ignores law, my lord. And then
We have had to.
Yes, my lord. We have to sometimes.
That is I'm going to answer, my lord.
At times, practical difficulties are there. You know the remoteness of the state.
My lord, so far, my lord, Arunachal Kansas, my lord, yes, my lord.
People are not even aware
They're
of
not-
anything, what to talk about legal rights.
Depends on my case to case basis, my lord. It cannot be uniformly applied to everyone, my lord.
Mr. Dolu, you are waiting for which matter?
You know, I am having two matters.
Huh?
I am having two matters. One is in
But
order.
today will not be possible. Today we have to rise early because there's an administrative committee meeting is there.
Yes,
And
but
we
I
like
am
to
waiting
have-
for item 19. Just I'll pray for 4 weeks time to file affidavit.
19 will grant.
Yeah, I am here.
19 is of which year?
No, these are contempt case, my lord. 19 order number.
No, which year matter?
This is 25. Recently filed.
Who is for the other side?
I am for the petition.
19 you are there?
Yes. And then, yes.
19 only.
Then what could your matter?
Only 4 weeks. I'm here, my lord, still with your lordship rights.
My lord, may I? Right. My lord, this is Radhesam, my lord. 2011, 5 SSC, 553, my lord.
2011?
5 SSC, 553, my lord. 21, paragraph 20.
Radheshyam.
Radhesam, my lord. Versus state of UP, my lord. Oh, all the area.
These are some of the dangerous concept. Okay, you should matter.
My lord, para 21 and 22, my lord, and 24, my lord. May I read, my lord?
No, we don't have a copy.
Oh, I have submitted the list of books, my lord.
इसी को ही देखो ना मार्क करके देखो ना देखो गणेशा
My lord.
Para?
21.
21.
21. 21, 20. May I read 21, my lord? Page 572, my lord. Para 21 is in 572.
Yes, please read.
Therefore, while examining the landowner's challenge to the acquisition of land in a petition filed under Article 226 of Constitution, the High Court should not adopt a pedantic approach, as has been done in the present case, and decide the matter keeping in view the constitutional goals of social and economic justice. The fact that though the right to property is no longer a fundamental right, the right continues to be an important constitutional right. In terms of Article 300A, no person can be deprived of his property except by authority of law. Para 22, my lord. In cases where the acquisition is made by invoking Section 4, read with Section 17, so, and High Court should insist upon filing of reply affidavit by the respondent's product and relevant products. My lord, here I will go to the third last paragraph, my lord. Para 22, my lord. The pleadings should be liberally considered and relief should not be denied to the petitioner by applying the technical rules of procedures embodied in the Code of Civil Procedure and Procedural Laws. The para 24 is the relevant one.
Yes, we have seen rustic.
Yes, rustic, yes. We may now avert to the ancillary question whether the High Court was justified in non-suiting the appellants on the ground that they failed to discharge the primary burden of proving that the state government had invoked sections 17.1, 17.4 without application of mind to the relevant consideration. In that context, it is apposite to observe that while dealing with challenge to the acquisition of land belonging to those who suffer from handicaps or poverty, illiteracy, ignorance, and do not have the sources to assess the material relied upon by the functionaries of the state, its agencies, for forming an opinion or recording a satisfaction that the urgency provision contained in section 17(1) should be resorted to, and or for the inquiry emphasized in under section 5A should be dispensed with. The High Court should not literally apply the abstract rules of burden of proof enshrined in Evidence Act. It is too much to expect from a rustic villagers who are not conversant with the intricacies of law and functioning of judicial system in our country to first obtain relevant information and records from the state authorities concerned and present skillfully drafted petition for enforcement of their legal and constitutional rights. Yes, sir.
That's all?
Yes, ma'am.
My lord, only two things, my lord.
There's no reply of reply.
No, I'm not replying, my lord.
Then what are you doing?
In the government affidavit, my lord, one special, my lord, paragraph is left out, my lord. My lord, I just checked the communication received from the deputy commissioner. My lord, where is indicates, my lord, that why the multiple factor one was applied, my lord. My lord, in lieu of 6 September 2026, 22, you're correct. My lord, entire Arunachal, my lord, the same ratio will be applied, my lord.
That will be prospective. We cannot make it retrospective.
Man, you lord, may kindly note, my lord, that when assessment was done, then when award was done, my lord. It's all after the, my lord, that the notification only after
After the estimation has been done based on a valid notification.
My lord.
You may have another notification. That you are also right in contending that the new subsequent notification is not the subject matter of challenge.
Correct, my lord.
But when do you apply?
Well, apply, my lord, obviously, it will be application will be prospective, my lord, no doubt about that. But you lordship may kindly note, my lord, when my lord final award was passed, my lord. It's after the, my lord, second notification, my lord.
Completely wrong, my lord.
No.
Because it was applied before coming in force of.
No, I'm talking about the award. You
Yes.
check the award date, then you submit. Your award date is different. Otherwise, I'm with you.
He is the learned age is referring to 14 to 2023.
Yes, my lord.
Which is post the 6 September 2022.
Correct, my lord. Yes.
We have understood your case, Mr. AG.
My lord.
We'll consider.
My lord.
My lord, page 90 maybe.
90 years, what is
Yes.
90?
This is the thing, my lord. This here, my lord. Everything is answered here, my lord. Page 90, my lord. This is, my lord, 21st March, my lord. Date is the, my lord, here relevant factor, my lord.
Yes, 21/3.
21/3, my lord. Yes. 21/3, they made a communication of revised estimate, my lord. Where, so my lord, this revised estimate was prepared before 21st March, my lord. Now this notification of, my lord, of 6 September 2022, my lord. That has to be considered, my lord. So before coming in force of this notification was applied in my case, my lord.
Page number 90.
We have to rise, we will make this, we wanted to dictate it in the court, not be possible. B. Picha, heard to be B. Picha, learned counsel for the petitioner. Also heard to be RB, R.H. Shamam, learned AG, as well as the M. Kato, learned deputy SGI. The hearing is concluded, the judgment is reserved.
Prior to notification.
Item 16 and 17, I said for all day to do this case, but I could not reach paucity of time, then.
We did not see you sitting. You were sitting in the canteen.
Well, that's, I had.
That did not give an impression that you were sitting.
Well, I had a word with my brother Rajesh. So I have some difficulty for 2-3 days coming. For certain.
We'll have a date convenient to both of you.
My lord,
this is item number
16 and 17.
Okay.
There is some urgency in the matter, Mala. This is
You tell us the convenient date for both of you, Mr.
Well, next
Sana
Monday.
will not be there.
Next Monday.
Next Monday, Mala, without no further adjournment.
Fine.
This is the second time I think.
No, he's not seeking adjournment.
My lord.
Today,
Yes, today.
Of time.
Yes.
Today he was waiting for this. He was sitting.
My lord.
He made an
We both have been waiting.
Okay, paucity of time will not allow the matters to be taken up today, 16th, 17th. Huh? As urgency has been expressed on behalf of the parties, list for consideration on Monday next date, huh?
16. Interim order to continue, my lord.
Interim order passed earlier to continue till the next day of listing.
Great.
My lord, submitted earlier also, my lord, I think 24 and 25.
Yes.
Mr. Dolo is also here, AG also is here. There is some urgency in this matter, especially from the defense estate side. Because infrastructure has to come up. May pray that this will be taken up tomorrow, my lord.
Tomorrow is not possible. Tomorrow already fixed matters. Tomorrow the list is also big and we have fixed matters.
Lord, I have already prepared this written statement also, only
No, yeah, but we have fixed matters. Tomorrow will not be possible.
day after.
We can have it on, you can have it on Tuesday next. And if Mr. AG is appearing, 24th is the date given by him.
My lord.
24th we can have.
Next week I have continuously parted and fixed matters in Guwahati.
23rd, 24th?
24th, 24th.
24th, man, other matter, your lordship has.
Yeah,
taken.
that is it.
That matter will take a lot of time, my lord.
Then 23rd?
23rd.
24 and 25, huh? Paucity of time will not permit the matter to be taken up today. Good stop, Tara. Considering the urgency expressed, list for hearing on 23rd, 23, 3, 2020.
23, 3 of 2. 23, 2.
23, 2. 23, 2.
My lord, regarding item number 9, my lord, this is 25 matter, contempt matter, I need 4 weeks of time to file affidavit. So 19, my lord. Orders. 25 matter, only 4 weeks time. I'm appearing for all 3 respondents, contemnants.
Okay, who is for the petitioner?
Petitioner, he was here only with the serving the matter.
He wants time to file affidavit.
A fixed date may be given.
Okay. Third, Sri
in the month of
Sri
March.
Vicha, learned counsel for the petitioners. Para, Sri Vaido, learned counsel appearing for the respondents has prayed for time to file affidavit in opposition. Para, according to matter is adjourned. Adjourned to be listed on
23rd. 23rd, I'm coming.
to be listed on
23rd, my lord, I am coming anyway that day. 23rd of February. Oh no, sorry, so March.
March.
Yes, my lord.
On 23rd of March, by which time the affidavits are required to be filed.
Yes, obliged.
My lord, in item number 26, my lord. My lord, I've taken the consent of the, my lord, the council for this thing. Matter may be, my lord, they fixed on 16, my lord, Monday.
26.
My lord.
Okay, Honor,
Yes, there is a urgency, my lord,
Madam, we have
expressed by the petitioner.
May on behalf of the petitioner, matter is to be listed on 16.
16, my lord.
Okay.
Development.
Rest, if there is urgency, court must give dates.
Item number 27 and 20, that may be fixed, refix on.
Court must give dates, don't worry. Okay. Court-
27 20.
Can you look into it? Okay.
Yes, on 17.
Okay.
27 and 20, on 17.